Also, I rated item number 38 Lordship. So getting better Lordship, but Lordship, due to my personal problem, Lordship, I'm having some urgent problem. That is, Lordship, I could not prepare this judgment, Lordship.
38.
Lordship. Can we next?
17 matter.
Lordship.
2017 matter.
No, because of that reason also, because Lordship, I have concluded almost my part only regarding the certificate. Lordship, I did not prepare that Lordship. Only for Lordship, next week I'll complete it on the 8th Lordship. On Thursday Lordship.
On 8th, all right, at the request of. Yes, Mr. Kyan.
So because partner, if she wants to take agreement with.
Is it partnered?
This is partner. She is already completed, almost completed.
At the request of MS SK Nargis, learned counsel for the petitioner, matter is referred till 8th of June for further hearing. Mr. SCKR appears for LCB.
May I actually mentioned I can number 30, 30. In the meantime, Petitioner
Oh. Mr. F.U. Borbuyan, learned counsel for the petitioner on instruction submits that the petitioner has been arrested in the meantime
on
on
26/5.
26/5. Therefore, the AB petition has become infructuous and same is not pressed. MS.SH Hadarika appears for the state. AB petition stands dismissed as not pressed. CD received. If received, shall be returned back. Yes. Yes. 31, 32 connected.
My 31, I have not received a notice matter.
But it is connected.
Take the first step on
31 matter.
Respondent to matter.
You are appearing for whom?
Private is not 2 matter.
In 31.
In my 32.
32.
Petitioner on both the cases.
Is the learned counsel's client also respondent in 31?
Minor.
Same respondent.
Same respondent.
This is the matter.
31, I will be allowed to take the first step.
Mr. Borua.
Mr. Bodole.
Bordeloi, sorry. Bordeloi, learned counsel for the petitioner. Raised for and is granted 2 weeks further time to take fresh steps on respondent 2.
2 on 31.
In item 31. And in 32, Mr.
Already gave it.
What do you want today?
I have some person declared this matter. The 2 weeks. I may be
Accordingly, let 31, 32 be listed after 2 weeks.
Why not the interim is in both the cases?
Interim order, if any, will continue to the next date fixed based on 22nd June.
In both the cases. Higher.
My wish, Lordship, I have to mention item number 60.
60. 60.
Supplementary list, 60.
Yes.
Which I may be passed over, Lordship. CD is also not available.
CD not available. How much time do you require?
Next week, Lordship, it will be on 9th of June.
About it, 9?
Lordship, in this status report was one form.
Status report of what? You wait for the turn, we'll have to look into the file. Just wait for your turn. We'll give you adjournments, but we'll have to call for the file, look into it. Right? Item number 60. 60, all right. Some status report is called for. Regarding trial. Okay. All right, then what do you want?
Status report will be called for 9th of June.
Status report of what? Of the trial?
No, Lordship is anticipated with or the perhaps Lordship present status of the case. Present status.
Investigation.
Lordship.
Why not call for the CD instead?
I don't want the CD.
So what status report? Once you get the CD, you will get to know what is the status.
Lordship. Lordship.
It's coming from which police station?
Tinsukia, Lordship.
Tinsukia, so it can't be on 9. You're on interim.
No, Lordship.
Then 20, 20, list on 20, item 60, no? 60, list on 20, as it is submitted by learned APP that case diary is called for has not been received. MS,
C Supreme, Lordship, on behalf of AM work.
MS so and so appears on behalf of Mr. A. Yes. Yes, next.
Petition, Lordship. I mention item number 41. Okay, ready? Lordship, in this case, the petitioner expired during the COVID period. So Lordship, we need.
41.
Yes, Your Lordship.
It is submitted by learned counsel MS
D Das on behalf of.
D. Das on behalf of
R Sharma.
R. Sharma. That the petitioner in the meantime has expired. Therefore, they require further time to complete their instructions. Then the matter be adjourned for 4 weeks.
In this case, I am appearing for the prior respondent number 2. Let a report call from the concerned police station also regarding the type of petitioner.
The report of
Concerned police station.
what for? They are making a statement. They are for the petitioners.
Yes, therefore,
Then some interim is there.
yes, sir.
Then we'll adjourn it for 2 weeks.
Yes, sir. Good.
List again on 20.
Look at the report, Lordship.
What report?
I see this.
Obligation. Well, Mr. Lordship, Lordship, I'd like to mention item number 58 of the list. Due to personal difficulties, my senior could not be available today in this court.
58.
58, Lordship.
At the request of MS. Your name, please.
Konyak on behalf of.
MN Konyak on behalf of Mr. Richard A. Chaudhary, matter stands.
It's the day after tomorrow.
No, adjourn. Adjourn for a week. Adjourn for a week. Come after a week.
After we.
CD is available, Lordship.
Retain the CD.
No.
List on 12th June.
Lordship.
We have petition.
Obligation.
Lordship, I beg to mention item number 57.
Hmm.
Supplementary dismemberment, my lord, kindly ask the method for the same reason. Here also CD is available.
List on 12th. CD received the retain.
Obligation.
With the concern of the other party, I'd like to mention item number 11. We have got a respondent number 2. But if the conducting counsel is too difficult, they may be. They don't. only
At
for
the
the-
request of learned counsel for the petitioner, matter stands adjourned for 2 weeks.
Can it be on 6?
No fixed date now.
Let's-
After 2 weeks, it will come. You make a mention if it doesn't come.
I will put the item number 17.
17.
One seven.
Your name, please.
Eight Alukar.
Mr. D. Talukdar, learned counsel, appearing for the petitioner. Upon instruction submits that he does not wish to press the bail application. Accordingly, the bail application 1567 of 2023 stands dismissed as not pressed. CD if received, be returned,
That will send back.
be returned back.
Next, please, sir. The person I'd like to mention item number 44. Because they get one for the person like some personal difficulties.
44.
Yeah.
At the request of learned counsel, Mr. So-and-so, learned, the item stands adjourned for 2 weeks. For 2 weeks.
Daily list motion be, I think, 1.
Yes.
And earlier your office was kind enough to reject it, minute, and that stage now today 62 days, minute. What I pray, minute, up to date case, I will call.
Yes.
In the case of hanging, minute.
That's a very pleasing way of putting it across. So please to reject it.
Anyway, after due consideration, minute, you have to.
All right, heard so-and-so, learned counsel for this petition, call for CD. This is coming from
It's from Kamrup itself, Kamrup district.
all for CD list on 13th 13th.
Item number 2.
Yes, Mr. Talukdar.
That regarding product name application. Rest of them 7523. The petitioner is an advocate. I organize that, but the way also there is a one.
He is identified by the accused. Identified by the accused.
That also we kindly see. With the FIR, there is no description of the mobile and the mobile number. Only on the basis of the vehicle, he was called to the police station, immediately went there, and he was arrested in this case. Only vehicle number was there.
We'll call-
Here you will also find, in page 16, there she identified.
Page 16.
But regarding the description of the mobile, what number, which mobile, whether it's Nokia or Samsung, nothing is there, no description. So at that time, I was in Panpata. Because I didn't snap, therefore I went immediately went to police station. They called me that with regard to some accident case you have wanted, so you come to police station. Accordingly, he went. And nothing was recovered from my possession. Like 24 days in custody. No purpose will be served.
Let us have the CD. This
Then
is
short date, it's from Sunday.
January. So short date.
Friday, Friday.
Not on Friday. Friday is.
Already 24 days is
second.
behind that.
You can have it on fifth, Monday. So then counsel to the petitioner, I was SH Boral and PP for the state. Call for CD list on 5th of June.
Item number 3.
Yes.
Sir, behind the bar of 38 days, madam. If I take it that, madam, informant laws are against the 4 members of the committee, petitioner and parents and the brother, madam. Allegation wrote and the section, madam, 3417376, madam. And in the FIR, entry that he was promised to marry me. And the occurrence of took place in the month of August 2022, madam. They have got on 1st April 2023, madam. So when he went to start the job at Delhi, madam, he was not available.
Heard Swenson and counsel by the petitioner. And MSSH Boral and APP for the state call for CD. Where is it coming from? Kamrup? Okay. We'll have it on 9th. This on 9th for CD. Only the CD.
Lordship, along with the medical report and
Along with medical report and 164 C.
Item number 4.
Under section 489A, 49B, pay currency matter. Directed on 7/4/23.
Heard Mr. So-and-so Leonard Council and Leonard APP for the state call for CD. List on
On 15th of June.
15th.
Lordship. Well, can you give 9th matter? Only 53 days, madam.
12th. We'll have it on 12th.
Orders.
12th of June.
Item 5.
Under 439 application, madam, possible fine FIR please 20. Madam, the accused number 1 for this bill application, madam. And the registered section is madam 406, 420 and 376 of Indian Penal Code, madam. Here, madam, I have annexed the next one. That the.
We heard so-and-so Leonard Council for the petitioner and MSSH Boral and APP for the state call for CD. Along with medical, 164 and medical. List on
12th.
13th.
Lordship.
For motion item 6.
Which criminal,
Warrant of arrest is due by the land trial court
Where is the order?
before the corona. Yes. And thereafter, court function was restricted.
That is, Corona is 2 years back. What were you doing?
Warrant of arrest issued on 22/2020, and thereafter, court function was restricted. Case number 15, and we see,
Yes. Then,
22/1/2020, both parties are present. PW said 22/2020. Complainant is present without any steps. And thereafter, share 21/4/2020. Share put up therefore remain closed due to necessary instruction of the honorable body regarding epidemic outbreak of coronavirus. The said warrant of arrest is pending. I have no knowledge about this theft, and during this period, my mobile phone has been lost, and there was no contact with my interest complaint. But I will appear before the trial court. This is united. In this united, there was a compromise discussion was also held. The petition also filed case number 13, compromise petition.
then? What happened?
Case number 13.
What orders were passed on this petition?
Method for some already paid to the complainant.
What orders were passed on the petition?
Complete payment, not completed. Therefore, this case was pending. They will pay the entire amount. There was,
Next date of appearance is on 13/6.
I will appear in the lodge. Till then, we have call.
Whatever case may be, what were you doing for 2 years? How did you come to know now? You got a new mobile phone. Your earlier mobile phone was lost.
There is discarded contact with the interest concern, and mobile phone has been lost.
Then how have you now been informed? That is what I'm asking you. How did you come to know?
I explained in the job. From the case numbers again. There are again. Due to one of the COVID-19 pandemic outbreak, the government of Assam also imposed various restrictions in the movement of the general public and such on the date fixed by the land trade code. Before the trial court, and that also lost this connection with this interest concern. The petitioner further states that he has no knowledge of the subsequent dates fixed by the land trial court. That's because functioning of the court proceeding.
When is the next date? When is the next date?
Actually, that is on
Page,
13/6.
page number
41.
41.
13/6.
Appearance.
Heard Mr. So-and-so learned counsel for the petitioner, MS SH Borel and APP for the states. This single petition is filed by the petitioner aggrieved by the order dated 11/5. Sorry, aggrieved by the orders dated. When is the first order?
First order is number 15. Case number 15, 22 to 2020. Hereafter, court concern was
by the order dated 20/02/2020 passed by the which court? CJM. CJM. CJM Ojali, Patsala, in reference NI case number 23 of 25. By the said order, warrant of arrest was issued to the petitioner, as the petitioner failed to appear before the court. Subsequently, thereafter, several other orders have been issued for execution of the warrant of arrest against the petitioner. Also, the last order issued was on 15/5/2023, on which date, and the next date fixed for appearance is on 13/6/2023. There are counsel for the petitioner submits that he had initially appeared in the matter. However, because of the COVID-19 situation as was prevalent at the relevant point in time, the court functioning was also restricted. He had failed to appear in the matter, and that apart, he lost his mobile phone and therefore was not able to contact the counsel. Also, subsequently, he somehow came to be informed that the warrant of arrest is still pending, and therefore he has approached his court praying for direction to interfere and set aside the warrant of arrest issued by the so-and-so court. Also, learned counsel for the petitioner submits that he will abide by any instructions or directions issued by this court, and thereafter he will appear before the court, before the competent court, and contest the matter. Where learned counsel, learned APB appearing for the state, submits that the petitioner be directed to appear before the court in compliance with the orders passed, as the next date fixed is on 13/6/2023. Also, having heard the learned counsels for the parties and upon perusal of the pleadings on record, this court is of the view that ends of justice will suffice if this petition is closed at this stage, directing the petitioner to appear before the court of CJM Patsala, Bodali at Patsala, and apply for and make necessary applications seeking appropriate orders from the court in connection with case number NI 23 of 2015. Full stop. If the petitioner, in terms of this order, appears before the court on the next date, i.e. 13/6/2023, the court of CJM Bojali at Patsala will recall the warrant of arrest issued and shall not execute the same against the petitioner. Also, the criminal petition is closed in terms of the above directions. Disposed. You will appear on 13th.
Item 7 and 8.
Also, 7 and 8 might not case I was more for.
Okay. It is submitted by Mr. S. Nawaz learned counsel that it is submitted by learned APP, MSSH Bora, that case diary is called for in these matters. Have not been received as yet. She prays for further time. Mr. S. Nawaz, learned counsel for the petitioner, submits that there is an interim order passed in AB petition 375 of 2023, which may be extended. Accordingly, let the matters be listed again on
15th of June also.
15th of June.
No, sir.
On which dates? The case diary along with
Along with postmortem report.
postmortem report we call for. The petitioner is already on interim bail by the order dated 10/4.
I am preparing for that.
2023 in AB petition 375 of 2023. Also, Mr.
Lordship, my lord, is appearing for the informant.
My lord, my name may be.
Your name, please.
Afia.
F.A. Ahmed, learned counsel, appears for the informant in both the cases.
Yes.
9,
I think 9 will be passport for the day. Yes, next week.
Passed over next week at the request of Mr. S. Nawaz.
on admission item 10,
Passing of the year, case number 2028 carrying out of an FIR dated 19/10/2018. Further in this case, after lodging of the FIR, page 18, page 8, the FIR.
Is what?
Page 8. It was lost by non-performance with the police officer mind. And the allegation is that some fighting was taking place between the police and the public. Subsequently, that informant has executed an affidavit, page 20.
Subsequently,
An affidavit was executed by the informant, page 20. Stating that the present petitioner was not involved in the case, and his name was wrongly.
what is his name?
His name is petitioner's name is Samnon Bora. Para 3 of the affidavit, very well.
Yeah.
That after investigation of the same case, IO filed searching the same case on 31/12/2018 against 3 accused and Samnon Bora, son of different village friends. The deponent has informed the associated facts to the IO of the case that because of the heavy work, presence of might have not been forwarded to consequently name of the Samnon Bora surface in the searching as absconded. It is declared by the paraphrase that the Samnon Bora was shown as absconded in the searching, but actually said Samnon Bora was not involved in the case. But due to misunderstanding, I mentioned his name in the FIR laws on 19/2008, though he was completely innocent and therefore, if the state Samnon Bora takes any lawful action in this regard to research from parents, the deponent has no objection being the informant of the same case. There are terms honorable both father order while studying the proceeding against so far petitioner is concerned. And while it was being noticed period as one number 2, the informant. Well,
Yes, what do you say?
This correct, the connection 3 is correct.
You bring it on record, file an affidavit. File an affidavit, let him file an affidavit in this respect. Mr. So-and-so S. Chauhan, na? R.S. Chauhan, learned counsel for the petitioners. For respondent number 2 submits that you'd like to file an affidavit to bring on record that the petitioner's name was wrongly shown in the FIR and is not involved with the offences alleged in the FIR dated 19/10/2018. Also, Mr. P.J. Sogia, learned counsel, appears for the petitioner and submits that the interim order that this court by the earlier order has already passed an interim order which may be extended in the meantime. Let the matter be listed after 2 weeks.
Yes.
Enabling Mr. Chauhan to file the affidavit as prayed for. MSSH Bora, learned APP appears for the state. List after 2 weeks.
All right.
Item number 12.
Yeah, please. In this case, we are telling the proceeding which is pending before the judicial administrative part of that.
Why?
But can't yes, doing it for. Our for custody of the child lordship government board will exercise section 97 of the CA.
Service report is awaited. Anyone appearing for respondent to?
We have taken steps so many times. Some relatives received the notice on behalf of the respondent number 2.
As per office note dated 11/5/2023. Service report on respondent 2 is awaited. Mr. Reti Sarkar appears for the petition and submits that steps have been duly taken on respondent 2. But none has appeared. Also, MSSH Bora for the state. List again after 2 weeks. Office to make necessary endorsements in respect of service of notice on respondent number 2. All right.
Items 13 to 15.
In 13 and 14 and 15, and that's why Mr. Games of the vehicle likes in the number 1. It is possible for the time being.
Why not hear it? Hear the matter, put it in a hearing. Why is it come for admission? The admission hearing.
On last occasion, your lordship directed to put it on admission. Otherwise, it was in hearing color.
One part is already heard. 202 has been heard. They went to Honorable Supreme Court. Honorable Supreme Court has already dismissed.
202.
They argued only 202.
Sorry.
And they argued only 202 issue and insisted on an order by this Honorable Court. And taking advantage of that order, this Honorable Court passed an order and then fixed the date for next hearing. They went to Supreme Court and Honorable Supreme Court has also dismissed that.
This was heard by which bench?
Under Justice Mir Alpatari.
Okay.
A preliminary issue was decided.
Then some other date?
Your Lordship may please.
And after vacation,
List on. You give a date?
After vacation is July.
Yes, yes. The calendar must be there on the 14th. Mr. A. Dhar, learned counsel appearing for the petitioner, submits that the arguing counsel, Mr. K. N. Chaudhary, is leading the matter, therefore matter be taken up on some other dates. Who's appearing, your name? Mr. A.K. Srivastava appears for the respondents. A joint request, let the matter be listed again on
19th July, possible. It's opening on 17th.
it can be in 20.
Normally we have ruled like before the Honorable Supreme Court, non-miscellaneous.
No, we are trying to dispose it of
Okay.
24th. Then it has to be 25th or 1st of August. whatever.
No, 27. Bharat Pai. NCLT Bharat Pai. 31st.
You give a date and fix it on Tuesday or Thursday, take it, give it to the
Tuesday.
court master. List on so and so dates.
Item number 16.
Yes,
Records of your present case as well as another case. But oh, that is, but for record, other case, record has not come to this particular case number 299 of it 14. Because there are two FIRs regarding the same incident. One relating to the present case by law, which in which needs to be received as minor. Another minor. So what the record were called by the.
as per office note 26/5/2023. Scan copies of LCR of Katigura PS case number 299
299.
of 2014. As called for by the order dated 26/4/2023 has not been received as on date.
My lord, I am for resport number 1. I have filed lordship of pleasure.
Mr.
AMS Majumdar.
AMS Majumdar, Learned Counsel, as appearing for respondent number 2 or sole respondent.
Resport number 1. Yes, please.
Respondent number 1 has filed the objections. MS SH, Mr. B.D. Gogoi appears for the state of Assam. List after 3 weeks.
Lordship, a date may be fixed. The interim continuing time. The interim is there.
Then let it go to July. Let it be on
Before vacated.
18 July. 18 July.
Before vacated. Lordship, a provision for second lordship and the petitioner does not appear in lordship and they come before the court lordship for party lordship.
Let the records come. Requisition for reminder for requisition of so and so be issued by the registry. LCI. 18 July.
All right. The interim order continue.
Interim order passed earlier, we can review it the next date. Yes, you are agreed on a date.
8th of August. 8th of August.
8th of August is this earlier matter.
13, 14 and
13, 14 and 15, joint request list on 8th of August.
interim order.
Interim order. It will continue.
Supplementary list for admission, item 51.
This one will take up in the second half. Let us complete the criminal matters first.
Bail hearing, item number 18.
Page number 7.
They are not named in the letter.
Hmm.
That petitioner was one, given the last 71 days and another is 69 days. They are not named in that.
Yes, CD.
CD received postmortem, my lord, here, they, could not confirm the cause of death, so this was sent to forensic laboratory, that forensic report not here, my lord. But here, main accused, my lord, first statement, my lord, he mentioned something, my lord, here. Take it, yeah, for it. Will I do it?
Intimidation against his wife from the offense.
This is the statement of wife, my lord, wife of the deceased. Next page, my lord, she disclosed some name, my lord, who was with that lady, my lord.
One person is Elias
Yes, my lord.
and the other is
Here, my lord, another person before your lordship.
Kiru.
You will name, my lord, by this lady. Elias not name.
No, Elias also. He's also there, only first part.
Yes, first, but that is there, my lord.
Uh,
That healing, my lord, that at that time, my lord, Akhil was.
How many days now?
71 days. Yes, 71 days from after the 69.
Mr. Is it Ahmed, council for the petition, and Mr. Maybe Google and people the states. This is VA bail application is filed by the petitioners 1 and 2. Who are seeking bail as they were arrested in connection with Mankachar PS case number 142 of 2023 under section so and so. Full stop. The learned counsel of the petitioner submits that by an FIR dated 17/3/2023. The informant one Jahangir Hussain lodged alleged that on 16/3/2023, brother of the informant one Kopil Hawk went to the house of the accused person's name from his own house. This lady was his wife.
Yes.
Accused person who was his wife. Also, it is alleged that the accused person, namely the wife of his brother, in a pre-planned manner, took him to the house of one Korkul Bibi and along with others killed his brother and locked the house, keeping his brother inside. On full stop on getting information over telephone, over the informant lodged the FIR and informed the police and lodged the FIR, and the dead body of his brother was recovered. Also, pursuant thereto, the petitioners have been arrested in connection with the aforesaid case. Also, since their date of arrest, which is 22/03/2023 and 20/03/2023 respectively, they have been in custody since then. Also, the this court by the earlier order and call for the CD along with the PM. Also, the CD is called for and the PM along with the PM report is produced before this court by the London APP. From the PM report, it is seen that there were multiple wounds, punctured wounds and ligature marks were found on the body. They said viscera and parts of other body parts were sent for FSL examination. Were sent for chemical analysis in the FSL. Also, however, the opinion regarding the death was kept pending till the receipt of toxicological analysis report from DFSL Kaidipara. Upon careful perusal of the case diary, it is seen that the statements of various witnesses have been recorded. And the matter is still under investigation. However, no charge sheet has been filed as yet. Also, from the case diary, it is seen that there are some materials which incriminate the petitioner number 2. Also, there are the materials available on CD, in the CD, prima facie, are incriminating insofar as petitioner number 2 is concerned in respect of the offences alleged. So, however, no such specific incriminating materials are seen insofar as petitioner number 1 is concerned. Also, upon giving my anxious thoughts, this court is of the view that, considering the period of detention and in view of materials and in view of the absence of any specific material which incriminate the petitioner number 1, the prayer for bail so far as petitioner number 1 can be granted. Also, however, so far as prayer for bail in respect of petitioner number 2 is concerned, in view of specific materials which incriminate the petitioner number 2, his prayer for bail cannot be granted at this stage. Accordingly, the bail petition is partly allowed. Petitioner number 1 is directed to be released on bail, subject to furnishing a bail bond of ₹30,000 with 1 local security of like amount. Subject to the following conditions, we shall appear before the IO on every date, subject to the satisfaction of CJM. Mangacha, South Salmara Mangacha. We shall appear before IO as and when required and till completion of the investigation, and we shall not attempt to influence any person, intimidate, interfere or tamper with any documents, and it should not move out of the jurisdiction of the so-and-so police station without written permission from the court. Full stop. With the above observation, bail petition stands closed. CD return.
Item number 19.
Yes.
I take a look at page 13 in the FIR.
FIR.
So 13 is the forwarding report, FIR is at page 12.
Yes.
There was a one stroke was given by their own relation, right? There was a demand of 8,000 who was taken on loan. He did not give out of excitement or anger, but he has given one stroke with a button, full button. And that has also been taken into hospital. He was recovered. And while he was discharged from hospital, he was coming back home, and on the way he died. My only prayer to your hospital, this death is not consequence of the incident. Might be a subsequent other matter. The reason might be. And innovative case has been charge sheet and matter. That I have applied for the bail matter. Bail has not been granted. 150 days I have completed behind the bar. My only prayer to your lordship matter, I have been given the release on bail so that I can face the trial matter and I can arrange my proper defense matter. And the statement I have annexed with my petition to your lordship. Under Procedural of your lordship, find that in the informant and his wife and the person who got the suffered injury, his statement, your lordship find that there is no case against women, or there is no case of 302 at all. At best it is 304.2 minor.
But now starts frame minor.
Charge frame, yes.
Frame under 302, not
Yes.
304 minor. Earlier it was registered under 304, But now search
Charges
number
framed.
303.
My only prayer is that I will be granted bail under any condition. But after charging also there are a series of judgment effects, but even for 438 also, Supreme Court has said that there is no bar or restriction to grant the bail.
Money, no.
150 days behind the person.
Yes, Mr.
Yes, Lordship, I have done from the LCR matter, that's now search train matter.
Let some evidence be taken.
No,
But I have annexed some evidence matter, 161 and 164 matter.
No, before the court, before the court.
But 164 also matter, you also fine. 164 I have also annexed, I with me matter.
Before the
164
court,
was
before the
also
court.
fine. There is no case with you.
No, why should we be released before any evidence is taken? Why? What, give us a reason why?
If you lordship, produce the evidence of the informant, I take your lordship. Kindly.
No, evidence Evidence has not started, has evidence started before the court? Then,
But when, if you lordship consider those evidence matter, a lordship find that what is my, how it has happened.
no, those evidence are irrelevant. Now you're before the court. Let the evidence begin before the court. Then
By
we'll
putting
consider.
me inside, I think when how
us-
there is nothing more.
Let us have some material to see what is your involvement insofar as the evidences are concerned. Unless you want to rely on some authority to say that no,
But that can be done by releasing on bail also, madam. I think.
we don't know. We don't know that.
And
It
then
is
you
for
go-
us to take a
By this one,
take a view whether at this stage, if we release you, what will be the effect on the trial?
I will not
That is the
defend-
decision,
I will
that
not
is the
defend-
decision which I have to take. Now that I can, that decision, it is easier to take that decision once we have some evidence coming from the court to see what is your involvement prima facie. Insofar as the charges framed against you.
But the material that available before the document, it will not justify the 302. Anyway, court has.
But the court has framed
I have not
charge
challenged
on these,
Yes.
and you have not challenged the charge.
But my only prayer is your lordship, probably granting of bail will not harm the.
Show us an authority if you have, we'll consider it. If you have an authority,
Yes, there is no bar to.
no, we know there is no
Yes,
bar.
Supreme Court decision is there, my lord. There is no bar to enlarge me on bail, my lord. I'm giving two judgments. Supreme Court, my lord, 438 also, after 30 also, 438 also, Supreme Court says that there is no bar, my lord.
ASCC निकालो भाई. ASC. This is 438.
Even 430 also Supreme Court granted bail, my lord.
We are
After
not,
charging.
we are not in doubt that we have the power to grant you.
Yes.
We are asking you on the facts of this case whether we should at this stage. That is the issue.
But in those two cases also murder case, my lord.
Maybe.
Patna High Court also given, I have one given with this, you know. There are others, the chair of the Supreme Court also. my lord.
You come up with decisions properly, we'll take it up some other day if you
Yes, I got no question.
list after a week, the request of Mr. S.C. Biswas, learned counsel, enabling him to place certain judgment before this court in support of his contentions. He wants some judgments to be, he wants some time to place, refer to some judgments.
I've given. 438, sir. 439 also I've given. I'll give, my lord.
Item 20.
That is allowed. 439 application, my lord. Which is 40 days behind the bar.
What is the FIR?
The card is page number 14, check. I put here page number 12. If it is a lady or not, she can say 40 days behind the back, they are minors and.
Their family, no female member is there to look after their minors.
Yes,
Medical report was called for that we have not received also. And from the statement of the witness, I have found also there was a fight because these two ladies were under intoxication also.
Information are also on
And the victim was already
40 days behind the bar.
stitches over head.
but you don't have that medical report. You have the medical report.
No, so
Then-
that is a very good question.
Has the medical report been called for?
Yes, not.
Injury report. Get it on Friday.
Not. Friday.
Friday?
It's already 40 days. There's a minor center. Lady. She will be released on bail. There's a no female member on their family also to look after their minors.
Try on Friday, not sir.
She will be released on bail.
Let us have it on Friday, give them one more chance to get the injury report. There is an order calling for the injury report.
No, sir.
Let's, on Friday, at the request of MS SH Bora Lana VP, enabling her to call for the injury report as directed by this court earlier. Mr. P. Daga, Joint Counsel appears for the petition.
Lordship, only the report CD may be retained.
CDB retained.
Lordship, okay.
Item 21.
When item number 21 object and still has been called for, check. Perhaps that is from there.
LCR not received. No. Case diary. Relevant case diary.
Along with the case study and see.
No, only case diary.
Perhaps scan copy.
No order.
Lordship, here in my petition,
In your,
the matter has been surseated, Lordship.
it is submitted by at the bar that the matter has been charge sheeted in the meantime. Therefore, registry to requisition the scan copy of the case records, LCR, from court of, huh?
Session case number 20.
Which court? Sessions court. From the sessions court. From the court of sessions, Dhemaji. Case number,
20, DH,
sessions case number 20, public DH, public 2023. LCR of so-and-so case to be requisitioned from the court of sessions, Dhemaji. List on. Fourteenth.
Lordship.
Obviously.
22.
Yes, madam.
Lordship, 439 application lordship and arrested on 29 4. Today is 32 days. Lordship.
CD along with 164.
Yes.
Fire is a base 8. Other co-editors are already released and paid, that's it, 2 co-editors.
What is the name of the petitioners here?
That's it.
Here,
Two
two petitioner.
petitioners.
Edit and my other.
That's it.
That's it, yes.
How many days now?
32 days.
You'll have to wait for some time. Add so and so then it comes into the petition. And Mr. B.B. Gogol and the deputy for the states. The petitioners have filed this bail application praying for bail as they were arrested in connection with Chancery TS case number 123 of 2023 under section so and so so and so. The by an FIR dated 29/04/2023 lodged by one Monju Sultana as the informant. It was alleged that the petitioners alleged that upon a request made by the petitioners for traveling with them for a ride, she agreed to the request made, and the petitioners, along with some other persons, took her for a ride on a vehicle bearing registration number A01W8493. Also, after crossing Soraigat Bridge, the vehicle was directed towards the jungle, and there the petitioners and other persons joined together and attempted to physically force themselves on her. However, she managed to escape that place and took shelter in a family. In the process, her mobile phone and bag, etc., were also taken by the accused persons. So that are pursuant to the filing of the FIR, the investigations commenced and the petitioners were arrested. The petitioners were arrested on 29/04/2023. Most of since then they have been in custody. This court, by the earlier order issued 18/5/2023, called for the case diary, along with the statement of the victim recorded under 164 CRPC. Also, the case diary called for is presented before the court by the learned APPs, and the same has been carefully perused. Full stop. From the statements made by the victim lady under section 164 CRPC, it is seen that there are specific allegations made against the petitioners, which and they're specifically and the informant is specifically and the informant makes statements which specifically incriminate the petitioners. So there are details of the offenses alleged to have been committed by the petitioners, which are found in the statement made under section 164 CRPC by the informant. Also, that apart, there are other materials available in the CD which incriminate the petitioners at this stage of the investigation. Considering all of the above, since the matter is still under investigation, the prayer for bail stands rejected at this stage. Full stop. CD accordingly returned. There are materials. Sorry. Yes.
Supplementary list, bail hearing BA items 52 and 3.
I think in respect of item number 52, it is the bail application notes. And item number 53 is 80. Now, with the lordship will find a FIR at pay scale notes.
Arising out of the same FIR.
Same FIR notes. The case and cross case notes. FIR pay scale notes, which is registered against us. The class of the indication is that lordship, the accused and his brother were present near the shop of one Nitul Burman. And when the LS meeting went to the shop of the Nitul Burman to ask his credit amount, they have assaulted him. That is the FIR. And the next day, FIR was lost. Incident, everything the incident took place on 6/5/2023, and FIR was lost on 7/5/2023 by the mother of the victims. Now, lordship will kindly come to the cross FIR. That is, lordship will find at page 25 loads. This FIR has been lodged by the wife of the owner of the shopkeeper, that is Nitul Burman. This is the fact of the case notes. What has happened? Actually, may I read also?
Yes.
Page 25 also. With due respect, I would like to inform you that yesterday on 6/5/2023, at around 10:30 PM, the above named accused illegally trespassed into our tea stall and abused us with slang language, and also vandalized our tea stall, thereby causing damage to it. Moreover, the accused touched my private part and thereby tried to oppress my modesty. When I met hue and cry, Jointo Deka and his brother Himanshu Deka came and rescued me. These are the petitioners before your lordship, Jointo Deka and Himanshu Deka. Hence, your good self may kindly investigate into the matter and take necessary action against the accused. This is my humble prayer. So this case has been registered as Mukaddama case number 287. And the case in which we have been shown as accused, that has been registered as 284 ones. This is the crux of the allegation. And moreover, the petitioner before your lordship, Jointo Deka is a reporter by occupation. He is a journalist. I have annexed the I-card. Lordship will kindly find at page 28 notes. Annex 5. He is a journalist of the news channel, that is the
Proceeding lordship. And there were some cases between the local police personnel because they were reporting of some news item. And that is why he has been falsely implicated in this case also. In fact, nothing had happened also.
Yes.
The injury is there, my lord. And that's definitely. That is also 24 days behind the to take up this.
Simple. Simple injuries.
Injury might have simple, but allegation of that snatching money might have, the money not recovered. Also, the apparently lordship is a small piece, found the shop owner lordship. He has taken separate.
But the allegations made in the FIR are supported by 2-3 witnesses, not the allegation that you have pointed out.
Lordship, I have already submitted before your lordship that I am a journalist by occupation.
Maybe.
But there are some.
Maybe. Then who has filed the other AB?
AP lordship, brother.
Brother. So what were you doing in the tea stall?
Lordship, our house is just situated nearby the tea stall, lordship. When she made hue and cry, then only we rushed to the place of occurrence, lordship. Otherwise, we were not present there.
Hmm.
Only upon making hue and cry, lordship, we reached there. This is some yard from our residence, lordship.
No, there is no finding in the CD to that effect, nothing.
What's the injury, so far the injury is simple, Lordship has already gone through the injury report, that is simple, and although Lordship only 24 days.
Money. You snatched away some money.
Lordship, that is the allegation, Lordship, but whether that is substantiated or not, Lordship, I mean, it's pure. But that is the allegation, Lordship. And he is lacking a small better nuts of Lordship. Wherefore we have got the 72,000 rupees on that particular day, that is also separating.
But you are a journalist, now you'll come out. You have enough resources to harass a poor person like him.
No, Lordship, that is not the fact, Lordship. Only because I have reported certain news articles against the police of the Mukalma police station. I have been falsely implicated, Lordship. And I have also reported certain allegations regarding the circle officer, but taking some bribe amount.
What happened to the other FIR? Is it? I don't see that here. FIR filed by the wife,
Lordship, that has been registered under section.
separate FIR.
Second FIR, Mukalma case number 287 of 2023, under section 448, 294B.
Mr. Gogoi, any information on that?
No, madam, that diary, no, not followed.
Can you get this diary?
Yes, madam, some time maybe.
How much time? Friday?
1 week, madam. The calm one.
1 week.
Related 24 days, Lordship, innocent person, Lordship, linguistic behind the bar.
Can you get it on 6th?
Madam.
6th?
6, yes,
Let us have it on 6th.
6.
Call for the case diary pertaining to Mukalmoa PS case number 287
Wait, just a minute.
of 2023 along with injury report if any. Let the APP will produce the state case diary on the next date fixed. Case diary in connection with Mukalma PS case number 284 of 2023, which has been received, shall be retained till the next date fixed. What about the AB?
Same set of allegation, Lordship.
Then that may be fixed.
Let it
But
come.
we have got interim connection in this AP, Lordship, because there is injury report is simple, Lordship.
Let both the matters come again on
6.
6 is just round the corner.
Lordship, who is behind the bar calling?
No, no, interim. So far as interim is concerned.
Lordship, that will considered on the 6th only.
This we can't give him interim now. We'll have to consider and see if it is possible to release him. on
It is
6th.
possible on the BA, Lordship, to kindly release him. Lordship, because.
Therefore, we have called for the CD to find out what is the status of the allegations made. Because see,
That is the cross case, Lordship.
That's right.
This case is concerned, except the injury is simple.
the cross case pertaining to the same issue.
Lordship.
So therefore, let us have this, put the CDs together and find out.
Lordship.
6,
Yes.
list on 6, call for so and so CD. huh?
Bail hearing AB 23.
Yes, charge sheeted.
No, my lord, the CD not received, my lord.
Oh, you just said charge sheeted, we could hear it.
No. Whether such a submitted under I want to know.
Mr. B.B. Gogoi and FPP submits that case diary call for has not been received list. Again, on 20 July 20. Interim. Why interim is required to be extended? Once you are on interim bail, it will continue. Why? Interim bail granted on 22/2/2023 shall continue till 20th of June, 20th of July, next date fixed.
Much obliged.
24.
Why?
LCR was called for LCR, so can not receive.
LCR has been received.
Then it's not shown in the list.
I see that was about what the this case, madam. I think not coming the person.
Something more important came. All right, at the request of Mr. D. Boral, let the matter be listed again.
The 2 weeks, madam.
After 2 weeks, and in the meantime, learned APP may also peruse the scanned copies of the case diary. Mr. A.S. Tapada appears for informant. 2 weeks.
25 and 26.
It is succeeded. Succeeded, part circuit, we get about the
Yes. Charge sheet,
LCR was called for that LCR not received.
charge sheet, no.
Yes. Here, what about logic, the altogether 27 has been named logic and 8 or 9% was arrested and thereafter 10% were charged sheeted logic and the charge sheet is a part charge sheet. So we have the another person, we have come to the honorable school logic for last 2 days, but that was not ascertained logic whether all personnel included or not. And in the meantime, on the second or third occasion, logic was being done interim to the old and aging person logic. The 6%, I think 4% were granted.
In which bill? There are two matters.
Logic 2 meters.
Bail granted where?
In
In 939.
26 logic, right?
Yes, 939. All right.
Some 80% are there, 82, 70, 70.
So list again on.
LCR might have maybe called for and it will CD in a saturated meter, the second book is saturated. Yeah, sorry, the CD.
It is submitted.
Help us, Lordship, because those persons were already.
They are not before us.
Lordship,
The persons against whom the charge sheet has been filed.
they are not before your Lordship. Because they are, someone has been issued, they have started appearing before the honorable. That person were earlier arrested. Succeed in a school, sir.
Learned APP submits that part charge sheet has been filed against persons who were arrested.
No, madam, my submission is such it submitted, my God.
Charge sheet
Part submitted,
submitted.
there is no such provision.
Okay. Charge sheet has been submitted. And therefore, he prays for. He submits that the scan copies of the LCR they call for in connection with which case? In connection with the case arising out of POCO PS case number 262 of 2022 from the court of JMFC, Kamrup. Will it be JMFC? No. Will it be SDJM?
SDGM Boku.
SDJM Boko.
Look, no, Lordship, can you see page 30, Lordship? Page 30.
30.
Oh, page 30. Oh, I think 26. He has even committed Lordship, even to the court of additional session just come to coming.
From the court of additional session judge, Kamrup Amingaon in sessions case number 20/2023. Call for scan copies of sessions case 2023/20/2023 from the court of additional session judge, Kamrup Amingaon. Mr. S. Munir appears for the petition. List upon receipt of case diary, scan copies. It will be listed upon receipt of the scan copies.
Person also 2%, I think, interim Lordship, that may be.
Interim bail passed in item 26 will continue.
Much obliged, much obliged.
27.
This is a
case of suicide by the victim in her parents' house, your lordship.
Hmm.
The supplementary affair was not alleging that the petitioner has committed 370 offense under section 376 for which she has committed suicide. But in fact, this victim, your lordship, she was residing with her only son at her parents' house after leaving her husband for last 10 to 20 years.
Who is the petitioner?
Petitioner is one communist Islam Hindu, your lordship, who is a co-villager, your lordship.
Who villager?
This victim was living with her only son in her parents' house. So after the death of the parents, the brother and his wife started harassing her, and they tried to oust her from her parents' house. Now, when she demanded a portion of her ancestral property, he kept on harassing her and tried to oust her, your lordship. Sometimes during altercation, this petitioner along with co-villagers came in support of this victim lady that she should be given some property, otherwise she had no other place to go. But subsequently she committed suicide, admitted in her house, your lordship. But the allegation is that he has committed offense under section 376. I don't know, your lordship, this will be revealed from the case diary.
But I remind the cause of death do not confirm, so research and forensic laboratory matter that the special report away.
Hmm.
That was linked to consuming of poisonous substance, your lordship.
Suspected to that is
And admittedly, according to that informant also, she consumed some poisonous substance in her home, and as a result, she died, your lordship. So far as the allegation of rape for 376, your lordship, that is required to be looked into. I have instructed that absolutely there is nothing like that. She did not make any affair, she did not give any complaint to any of the local people. And after her death, her brother has made up a story.
No, but why against you?
Lordship.
Why against the petitioner?
Because earlier he along with his brother-in-law, they stand up in cover of this lady that she should be given some property, otherwise she has no other place to go, your lordship. Not only the petitioner, even his brother-in-laws have also been accused in the case. Made it, your lordship, made it the affair, your lordship.
Hmm.
Like all other days in the evening, my sister aged about 40 years, namely so and so, used to go to the house of so and so in the same village for doing work of cutting of petal nuts. On 14/12/2022, your lordship, that is the day, at about 9 p.m. when my sister was returning home from the house of the Saint Jamaat after doing the work of cutting of petal nuts, accused number 1 forcefully taken over my sister from the road and committed rape on my sister. Thereafter, my sister went to the house of accused number 2 to 5 and gave
Let us see the case diary. Let us see.
postmortem report. I don't know what is whether it's available or not.
postmortem is here, sir. That is sir.
So far as death is concerned, she has reduced some poisonous substance admitted in her home. That is
Which jewel? Which jewel?
where is not reported.
Some relation is there.
Okay. From the case study. That may be. The allegation against the present petitioner is that he has committed offense under section 376 at least.
Some reference to the petitioner.
Yes, I got that. I don't know whether there is anything regarding the reform matter. The allegation against him is that he has committed rape, your worship, and that is the reason which led to the commission of suicide. Otherwise, he is a married person, your worship, having a son of 9 years. And they are co-religious. Immediately after the affair, he has committed suicide by consuming poisonous substance in alcohol.
That is not there. Report is not here. Toxicological report is not
The
here.
affair is disclosure by the brother.
FIR it is disclosed, but there has to be a report. There has to be a report to say that the expert that there is poison or no poison. In fact, the PM report does say that there does not appear to be a case of. Sorry, it is a case of poison.
Maybe.
That is the tentative opinion. But final report is awaited.
But the brother who has lost the affair, he said that she has consumed some poisonous substance. Allegation against me is not giving any poison. Allegation against me is that I have committed rape, as a result of which she committed suicide. Otherwise, it is a case of suicide. That is what is there in the FIR. But the suicide was committed because of the commission of rape by the petitioner. That is the allegation.
Okay, we'll pass some order, let us think.
Okay.
We'll pass some orders.
If there is legal worship, I have no case.
We'll have to go through this case diary properly.
But if it is not that the allegation against me is that he has committed rape, for which she has committed murder, suicide.
It doesn't-
Item 28.
Does not appear to be, but
Anyway,
let me confirm by going through the case diary properly.
I'm
Yes,
sure.
yes. Mr. Das,
Page 9, my lord, directed me to find additional activities also. We said profession of 25 lakhs rupees, my lord. He was a agent, my lord, of a distributor shop, my lord, mobile phone. Actually, that was page 9. I found that, but since last 22, it is noticed that the accused did not deposit the whole amount collected from various shopkeepers, showing extraneous ground. On inquiry, I found that the accused though collected money from different shopkeepers and thereby issued money receipt, but did not hand over the cash to me and thereby misappropriated sum of rupees 25 lakhs approximately yielded. That the accused being entrusted with the AB distributor collected money by the of distributor and have dominion over it. And thereby dishonestly misappropriate my money against the direction of law. Accused may commit the offense in league, other employee staff, and they may also involve in the aforesaid step. When you then, well, as the money has been deposited, well, these are being matter. So additional affidavit cost was directed to the final.
what have you brought on record?
Yes, my lord. That is the case, my lord. Additional affidavit, my lord, paragraph, my lord. And there is a lordship, page 12, paragraph 2. That during the proceeding of the aforesaid case, it is found that your petitioner already deposited various amount 1,422 to 10,1222, out of which the informant himself received online payment 2,11,000 rupees. Similarly, as per direction from the informant, your petitioner has made online payment to his wife, brother, manager, cashier, informant, namely Nomita Poddar, Deepak Kumar Poddar, Om Prakash Sharma, Ajay Moore, respectively, who collected rupees 12,06,370. Similarly, for rest of some amount also was also deposited to Deepak Kumar Poddar family, 1,30,000. Deepak Kumar Poddar own account 1,01,565. Om Prakash Sharma 17,500.
Who deposited these amounts?
The petitioner, this accused petitioner deposited the amount. As per
Where did you deposit? To the persons?
Yes, well, they are the family members of the informant side, my lord. They are, the informant himself directed, my lord, to deposit in this website.
Deposit from where?
My lord, collect the money from this, my lord, shopkeepers, my lord, and the,
So the money was with you.
Yes, my lord.
It was
Money was collected and immediately after the sale, my lord, that has been deposited. No,
You're not getting the point. You look at what you have stated.
yes, my lord.
You have made online payments.
Online payment.
So online payments will have to be made in respect to a particular bank account.
Yes, my lord.
Whose bank account is this?
And these are the brother, wife, etc.
You made online payments.
Online payment.
From whose bank account?
From the, my lord, shopkeepers, from the shopkeepers and the, my lord, purchasers, my lord. Collecting the money.
You're not understanding what I'm asking you. Yes. Yes, APP, what do you say? Because here APP.
Here regarding this aspect, we have not got the affidavit, and regarding those payments, my lord, that CD is actually last up to date till 24/2/2023. Those aspects are not here. My lord. That's
Why the CD is not updated? Meaning
why-
either they have completed or they are not interested in pursuing.
19 lakhs already, my lord, given back to the informant.
So 19 lakhs you collected,
Yes, my lord.
deposited where?
For,
How did you collect in cash?
yes, collected, my lord.
And then what did you do?
That amount has been received by the family members of the informant.
Received from whom?
From the customer, my lord.
So what is your role there?
Yes, I am the agent, my lord. Of the distributor.
Huh?
I was directed to collect the money.
From collect the money from whom? From the customers.
shopkeeper, Customer, etc.
Yes, and then what did you do with the money?
I have deposited that amount.
Where?
To the informant family members.
Why?
Because the informant himself directed that I may also deposit to my wife also, brother also.
How did he inform you?
But these are all papers there, madam. And I have furnished one copy to my learned friend also, information, madam. 19 lakhs already deposited.
Yes.
May I please?
You are who? Who are you?
I'm on behalf of the informant. As per the instructions from the informant, such someone has not been received, and we are not admitting any of the amount, one or two amount which he has received.
What amount is to be collected and by whom? As whose instructions?
As per the instruction of the informant, he has to collect the money from the customer and he has to submit it in the office. But that amount was not.
What
submitted.
business do you?
That is a distributor of Open Mobile.
You are a distributor of
Yes.
phones, mobile phones.
Yes,
He's an employee under you.
Yes, sir. He has to collect the money from the shops for where we have we provided the mobile phone.
On installments.
Yes, sir. And that money has to be, he has to return back the money to the office. But that money was not returned to by him. And in the month of, before filing of the FIR, after considering some of the admitted amounts, we have found that 25, there is a misappropriation of 25.
So why did you distribute it to other persons?
Some of the persons which CS mentioned, we are not aware of that.
No, other person because as wife also had received that. Nomita Poddar is there. Nomita Poddar wife.
No, but why did you are supposed to collect money and deposit in the
Yes,
account of the
But
shop?
Yes.
Yes, madam.
When-
But I was directed in this way.
No, that mere direction will not do.
Yes, madam. But these are the all.
What are these papers?
These are the papers in which way I have deposited the amount to their family members. Many are.
You go and show it, you go and produce it before the
In paragraph number 2, he has mentioned a huge amount of money, but yes, the papers which he has annexed with this affidavit, the amount is very small.
No,
And half of the persons we do not know.
Their papers is there.
No. What is this process of sending money to these people?
There was no process, Your Honor. He was not given any instruction to submit money to this persons.
But except that.
Yes, Mr. VP, get your updated CD.
Yes, madam.
Get it by end of June. 22nd June. Let the updated CD be called for. As prayed for by the learned council, APP, let the updated CD be called for. and or by the next date fixed, let the matter be listed again on 22nd of June. What interim can we give you? The CD is
Given back the amount.
what given back? Why did you give back the amount to these people? You are working in a shop.
But they accepted in this way.
What is the meaning of they accepted?
Yes,
Who will not accept money if you give them?
but that was the direction of the informant.
Where is that direction?
Let the city come, my lord.
Where is the direction?
That is not mentioned by the informant.
Then,
But the informant, why this, my relative is not refusing, my lord. Because I have some copy to him, my lord, very first day, my lord. Every time of.
No, we are not the investigating agency. You say all that before the investigating agency.
Because my lord, my lord,
Uh,
55.
Mr. H. Das appears for the petitioner and Mr. J.K. Bhuiyan has entered appearance on behalf of the informant. Whatever you say it to the APP. We are not entitled to hear you. You assist the APP, whatever you want to assist. Yes, list again on 22nd. You take back these papers.
Item 29.
Here is the lordship.
Yes,
438 application your lordship for the sections involved of 489A and 489C your lordship. Earlier it was rejected, and new ground is said your lordship. That is para number 7 your lordship. The petitioner's father needs medical attention your lordship. For that we want to take him outside. That we need your lordship.
where are the documents?
Lordship, I could not get the documents.
Why?
But CPA were right.
You want to take your father, where the documents will be available with the police?
No, Lordship couldn't get the documents because I couldn't
You get it on record. Bring it on record.
on next day.
Yes, whenever you want it.
In this case, CD may be redundant because the FSL report is not clear.
You call for the FSL.
Lordship, one more prayer, Lordship.
Hmm.
That's one prayer, Lordship. There were two accused persons were caught, your Lordship, and then one of them has been given bail. One has been given anticipatory bail, and other one is still is still behind the bar. So, Lordship, primary accused persons have been arrested. So, for the time I will be protected, Your Honor, because I was not arrested with the position of the counterfeiting notes.
You are not even arrested. This is an AB.
Yeah, I will be protected.
You are not arrested because you are not available.
Because they have not found me in possession of these counterfeiting notes.
You are not arrested.
My name has been indicated here only because one of the accused person took my name and he knows me because.
Where is the order rejecting your petition?
Answer very fair, Your Lordship. That is annexation number 2, Your Lordship.
Election number,
2, Your Lordship.
page number
13, Your Lordship.
13.
1, 3.
You have been given bail.
No, there were two petitioners, one got bail.
One was, and I was not given bail, Your Lordship.
Okay.
That's why this particular prayer, Your Lordship.
Petitioner 2 was given.
Yes, Your Lordship.
You get your documents, let us see. If that is your ground, there's some material is required.
I'll get them a date, Your Lordship.
At the request of MSP does learned counsel for the petition, the matter stands adjourned for. How much time do you require?
Lordship, maybe after 2 weeks.
2 weeks.
Maybe take
Mr.
a date.
KK RR Kaushik, learned APP appears for the state. It is submitted that FSL report is not available. The same may be called for. You all need to send a CD. Petition APP is permitted to send back the CD and call for the FSL report along with the CD. List after 2 weeks.
Lordship, can it be fixed by date, Your Lordship? But
It has to be fixed by date. Give a date, please.
On 16 minutes.
it will do, Your Lordship. 16/6.
16 already. 16.
Take your date.
Supplementary list. Bail hearing AB item 54.
Yes,
Please, if it is been prepared under 438.
CD,
CD receipt minor without FSL.
then learned APP, Mr. R. Kaushik submits that FSL report has not been received as yet. Accordingly, he seeks liberty to send back the CD and call for the FSL report. The prayer is allowed. Mr. S. Islam appears for the petitioner. By order dated 28/4/2023, petitioner has already been granted interim bail. The same shall continue. List in July. 19 July.
55,
Yes, no, this would have to be paid now. Already finished payment now. The FI is paid 19. Yes, we need to put what would happen?
CD not received as submitted by CD call for has not been received as submitted by learned APP Mr. So and so list again on.
Year starts submitted. By search number 26.
You're sure?
Yes, sir, it's written in our petition.
Mr. R. Kaushik, learned APP submits that charge sheet in the matter has been filed by the charge sheet number
20/2023,
20/2023 dated
dated 17/5.
17/5/2023. Accordingly, the AB petition stands closed. MSP Bora appears for the learned counsel appears for the petitioner. It is seen that by the order dated 3/3/2023, interim bail was granted to the petitioner. Post of accordingly, the benefit of the interim bail will be extended for another 10 days, 15 days, enabling the petitioner to appear before the competent court and pray for regular bail in the matter. AB petition stands closed.
On receipt of some pilot. Regularly.
You appear before the court.
Okay.
56,
CD not present.
CD call for not received based on 26th of July. Interim bail granted earlier shall continue.
59,
Hello, is it bail activation motion? Is there was called for this diary basis?
Where is your FI?
What has happened, Lordship? Allegation is that Lordship, this present petitioner before Lordship, the informant met the present petitioner in Mumbai, Lordship, and he had promised the informant that he is going to secure some work orders of the DRDA department at Cardinal Autonomous Council. Therefore, what has happened? Some amount of allegation is that some amount of money was paid. He came to Guwahati and he inquired to the DRDA office in Cardinal Autonomous Council in Dibu, and he found that there were no such work orders were issued in the name of the informant. The informant, because Lordship, he is the partner in a solar installation.
Why does he have to go and get the work order? Work order is issued in the name of the informant.
Yes.
So why the petitioner is required to go and collect it?
Petitioner did not go, Lordship. They had some business relation between them, Lordship. He was an acquaintance of with the informant, Lordship. He had informed him that there were some works going on in Cardinal Autonomous Council, and in such circumstances, Lordship, the informant, Lordship, went to the Cardinal Autonomous Council to inquire about the projects, Lordship. Now, allegation is that some amount of money was paid. Lordship, it's a government contract, if at all, Lordship, auction, if any, are advertised through the GEM, Lordship. The online portal is there. And Lordship, these allegations at all, if at all, Lordship, would not constitute any offense, Lordship. Because how, Lordship, being a partner of such a reputed company, it is his own statement in the FIR that he invested such amount, Lordship, by paying some money to the petitioner. partner of such a. Partner of such a big solar installation company, why not you intervene on this thing?
Yes,
Yes,
Mr.
daily receive my better device.
What materials?
Right, what's that? The allegation is that my lord, the informant finance some amount might have paid to the petitioner, my lord. But there is no such written agreement or like that, my lord. The business part of my lord.
What is this form of recording?
My lord, that the conversation between them, my lord.
What language is this?
That is okay.
Is it permissible?
And that's a call details that may be.
No, not all details. This is recorded in Hindi with
Oh, that
Roman alphabet,
I am doing.
Roman script.
Yes.
Who is the informant?
Informant is the businessman of Mumbai.
What is his name?
He is from Mumbai. He is Rahul Prabhakar Rani.
You are on interim, no?
No.
You produce a bank details? Let us see. They have made statements that they have paid you through accounts in your bank account. It is shown here in the bank statement, their bank statement.
Yes.
Reflected here. You will have to say that this amount has not gone to your account. Your name is reflected here. Then
Money person.
there categorically your name is reflected in the NEFT transactions. You want to take instructions? Mr.
It
Ganguly,
will be better, my lord, if my friend will file IM, my lord. Details, then only details will come, my lord.
or
That money, regarding money, my lord.
he doesn't want to file, he knows it is available with you.
That I can.
Why should he file?
That I cannot comment.
Mr.
Instruction.
Mr. A. Ganguly Lalit's counsel for the petitioner, 6 short take to complete his instructions. Mr. Didi Gogoi, Learned APP, affairs for the state, who has produced the case diary. Let the matter be listed again on. When can you get it? How much time do you require?
Next week.
22nd June. Or you want it next week?
Next week.
Next week would be 6th of June. CD received the retained till the next week first.
Item 61.
CD वापस कर लो. Yes, Mr. Wilcom, yes.
Very easy. 430 application is registered under section 120B, so B at 34. Taking the three accused. And I'm for the accused of 20.
Yes.
One is the husband of the deceased. Deceased has committed suicide because. And this FIR is lodged by the brother of the deceased because at this stage.
Yes, madam, 304B, postmortem report is not
Available.
with the postmortem report is
You
required.
call for the postmortem report. Dowry.
The remember this petitioner number 2 and 3, this accused number 2 and 3, they are the petitioners, so they are living separately, this separate house, Miller and
Who are they? Who are they?
one is brother, accused number 2 is the brother of the accused number 1. And petition number 2 is the brother-in-law, he is 100 kilometers away from this.
It is submitted by the learned APP that the postmortem report as called for is not available in the case diary. He seeks a short date to call for the postmortem report. Also, Mr. R. Goswami, learned counsel, appearing for the petitioners, submits that the petitioners, although named in the FIR, are relatives of the person named as accused number 1. They are what? Brothers. Petitioner number
Petitioner number 1 is the brother,
is the brother of petitioner number, accused number 1, named in the FIR, and petitioner number 2 is the brother-in-law of the person named as accused number 1 in the FIR.
they are living separately about 100 kilometers away.
It is submitted that the petitioners 1 and 2 live in separate places away from the residence of the person named as accused number 1,
Accused number 1.
as well as accused number 1. Full stop. Then counsel for the petitioner submits that both the petitioners, what do they do?
Well, one is carpenter. At paragraph 3 below.
The petitioner 1 is a carpenter and the
Yeah.
petitioner number 2 is a cultivator,
And this cultivator.
and they are not at all connected with the incident. He therefore prays for interim protection till the in the meantime. Also, having heard learned counsels for the parties, let the matter be listed again on August 1st of August, enabling the learned AVP to call for the CD along with postmortem and FSL if any, as well as 164 statements. So in the meantime, if the petitioners are arrested in connection with Jogi Gopa PS case number 143 of 2023 under section so and so, they shall be released upon furnishing a bail bond each of rupees 20, bail bond rupees 25 each with one local security of like amount to the satisfaction of the arresting authority and subject to the following conditions. They shall appear before the IO within 10 days from today. They shall not hamper or tamper with the evidence. They shall not influence any person or witness connected with the case, and they shall not move out of the Jogi Gopa PS police station without written permission of the list accordingly.
Dealing with for orders item 33.
Wait, is your lordship? Lordship, isn't it as per petition, last of this, the notice was issued to as per number 2 your lordships.
AD card not received. Await service report. As per office note dated 26/5/2023, service on the sole respondent is awaited.
There is the interim, the interim will continue.
List. After 4 weeks. Interim order passed on 27/4/2023 shall operate till the next date fixed. List on 2nd of August.
Deeply obliged.
34.
As per office note dated 26/5. We have filed today.
We filed it today, your lordship. We'll be appearing from, if some time can be given to
Mr.
A.M. Boro.
AM.
A.M. Boro.
AM Borwal and council submits that he has received instructions to appear on behalf of the respondent, sole respondent, sole respondent, and he prays for some time to complete his instructions. MSK Yadav, learned counsel, appears for the petitioner. Let the matter be listed again in July.
In July.
27th July.
Your lordship, not 27,
Then-
before that, because I will be out of state and like
20.
20. Post, I'm going on 19th.
When are you coming back?
In September.
Post vacation would be a preferable time, your lordship.
27th or June?
Yes, that will,
We'll have it on 27 June.
yes, that will.
27 June.
But the interim order may be
The
extended.
interim order passed earlier shall continue till the next date. If you can't complete your instructions, you take time till September. Good for you.
Much of it, much of it.
35,
Yes, Mr.
Your art will be taken, will be serving the, filing the affidavit. Not tomorrow, the post, by tomorrow will be filing.
It is submitted,
What the record has not come.
it is submitted by the learned senior counsel, Mr. P.D. Das, that steps by Dusty, as directed by this court, has been effected on respondent 2.
So I am appearing.
You are appearing on it.
Yes,
And affidavit to that effect will be filed. Full stop. Mr.
I am Sundar.
R.A. Mazumdar, learned counsel, has in the meantime entered appearance on behalf of the respondent number 2.
One order.
Mr. B. Sharma appears for respondent number 1, the state of Assam. Then you want to file it,
Yes.
you want to file your objections. Learned counsel appearing for the respondent number 2, prays for 4 weeks to file their objections in post op. In the meantime, the interim order passed on 27/04/2023 shall continue till the next date fixed.
After vacation.
List again on 27th of July. 27 July.
36,
The service report is awaited for estimate number 2.
As per office note dated 26/5/2023, service report on respondent 2 is awaited. MSSH, what is your name?
Peace over your.
P. Sobri appears for the petitioner. Mr. B. Sharma for respondent number 1. List after 4 weeks.
Russell, interim order passed.
Interim order passed earlier will continue.
daily list for hearing item 37,
Yes.
Last time, they were achieved, the collector informs them whether the appellant was released from jail or not. But I have contacted the jail authority, and I have ascertained that one was released on in June of 2020, and the woman was also in August 2020. Both of them have already been, they have served the sentence and have already been released.
Now what do you want to do?
Whether the is pending.
No. You want to press the appeal or you want to withdraw the appeal?
No, order is not. No, order may be given on the.
On merit, okay. Then we'll hear it. What is the? You are ready for hearing today? This is on NDPS. Is this NDPS? NDPS.
Yes.
Who's appearing for, you are appearing?
I am appearing, my lord. Judgment was in the 2012, my lord. And my lord, as per instruction, last order, lord,
Yes.
last order, my lord. In the last order, my lord, it was directed to the parties, my lord, to take the information whether they were already released. from
He
the
has
jail.
already submitted,
My lord,
they released.
My lord, they are released.
Now,
Now the case is new, my lord.
how?
Made, my lord.
How?
Already they have undergone the.
Maybe, but then the finding of the
Yes,
court that
yes.
they are guilty of the offense
My-
remains.
My lord,
Unless they want to withdraw the appeal,
Right.
which they are not,
my lord.
then.
But in this case, 3% have got down from paying in Boolean mallet. And they have boarded a multi car to go to one place. And on the way, police stop the car. When the police stop the car, one of the 3%, this is Dilip Chakraborty, you are sitting on the backside seat on the left side. He had thrown away a packet in the road.
Hmm.
The driver have hard opening the road by the Dilip Chakraborty. And when the police stopped the vehicle, Dilip Chakraborty had picked up the packet and it was seized by police. Now, my appellants, Shamal Das and Anwar Begum, they are co-passengers in the car. Now, whether they actually can be convicted for being co-passengers, that is to be seen.
So they were in the vehicle, but the goods was thrown out of the car. Packet was thrown out of the car. By whom? Who threw out the packet?
Dilip Kumar Chakraborty. No, he is not the appellant here.
He is not the appellant.
He is not there.
The appellants are 2 and 3.
Shamal Das and Anwar Begum.
Okay.
The police have in the record stated that Anwar Begum is Dilip Chakraborty, but minor actually Dilip Chakraborty is not our husband. As per your record, I have obtained a copy of it. Our husband's name is Cyprus number. The police have mentioned in the case that Dilip Chakraborty is our husband. So these two persons, in my involvement, may not be involved in the case. And that is to be said.
You argue the case, we'll hear you. You argue the matter, we'll hear you. You have to argue the matter.
Yes, this is responsible.
Huh?
I don't have anything more to say.
Huh? Sorry?
I don't have anything more to say. This, what I have said, this is the argument. The seizure of the packet cannot be doubted, my lord. But if it is seized, it was seized from Dilip Chakraborty. The other two were co-passengers of the car, and since they are co-passengers, they were implicated in the case.
Yeah, you'll have to take us properly. You cannot say that this is what I have to submit. You'll have to take us to the depositions of the witnesses. You'll have to take us to the seizure list. You'll have to take us to the provisions.
From 4/11/2011, at 11 AM. 3 persons, Dilip Chakraborty, Shamal Das, and Anwar Begum, got down from train at Muriani police station. And
Yes.
they,
Just 1 minute. They will come on. যদি আহিব পাৰে দুটা বজাত আহিলেও যদি এটা available নাই এইখিনিত আছে যদি মালাই দিও যদি নাই তেতিয়া 2টা বজাত লম Are you available here at 2 o'clock? 2 o'clock. Second half will take up.
I guess 39 and 40.
Because of the last time it ever.
Yeah, item number 40, I am appearing. Here, my lord,
39.
39, probably my friend is appearing. My lord. My friend
Yes.
is appearing. Here, my lord, on 26/5, the respondents have filed their objection, my lord. I may be allowed to file my reply, my lord.
Like 26/5 when?
26/5/2023, last Friday, my lord.
Then. What is the, you have filed this
Yes, my lord. The criminal petition is filed by me, my lord.
against which order?
Against my lord, order taking cognizance.
Cognizance.
Yes. This is the second round of litigation, my lord.
What are your grounds?
Second round of litigation.
What are your grounds?
My lord, basically my grounds are, that, section 6, the consent required from the state government is not available. The petitioner is a state government employee, my lord. For investigation, by the CBI, my lord, consent as per section 6 from the state government is required. My lord. This is my lord.
What were you doing? You're government servants.
Yes, my lord, I am government servant. My lord. Now I am
Working as?
Then I was working as director AIDC, my lord. Now I am retired.
And this proceeding started during
My.
your employment?
Yes.
While you were in service?
Yes. The main allegation is that, when I was in service, my lord, there was a coal distribution policy, agreement between the state government and the central government, my lord. And the central government has allotted some amount of coal to the state government for distribution in the small scale industries, my lord. Particularly in the, my lord, tea garden industry and other small scale industry, my lord. The allegation is that, in distribution of this coal, my lord, there are some misappropriation, etc. This is the main allegation.
What has AIDC got to do with coal distribution?
Actually, the AIDC was the nodal agency of the.
For release of the funds?
No, madam.
Then?
AIDC was the nodal agency of, who is required to look after the distribution of the coal, madam.
Distribution of coal?
Yes, madam. The coal was allotted to the state government, madam. That is, central government, madam.
Distribution for what purpose?
For the small scale industry, madam.
For what purpose?
Madam,
As a fuel?
as fuel. Particularly in the brick industries and tea industries, madam.
Okay. At the request of Mr. Sharma,
Hello.
MK Sharma. The matter stands adjourned for 2 weeks, enabling him to file a reply to the objections stated to have been filed by the respondents. By who has filed it?
Madam, CBI, madam.
By the CBI. Who is appearing for CBI?
Madam, Mr. M. Hello is appearing for the CBI, madam. Right now, I need to quickly take a look. May I pray, madam, who's called prayer, if possible, 4 weeks, madam. It's a
Why?
huge every day, madam.
4 weeks. Is it available here? Not available here, is it?
I have received my copy on 26/5/2018, last Friday.
Maybe it is not even filed.
Right.
It's not available here. You call Mr. Halloy, we'll find out. If they have not filed, then what is the point in giving you adjournment? They may not decide to file it also.
Yet to matter.
That too.
I'm okay.
Item 42.
Preparing.
Preparing for?
CBN.
I'm not gonna talk to you.
Yes. You have filed a new affidavit.
We have filed
When?
26/5 version.
26/5. MS so-and-so Leonard counsel appearing on behalf of CBI submits that
Actually, I am on behalf of Mr. M. Halloy for CBI. I am on the CBI.
you are here, so we'll record your name. MS so-and-so appearing on behalf of Mr. M. Halloy appearing for CBI submits that an affidavit has been, objections have been filed
Yes.
in the matter on 26/5/2023. Full stop. However, the case records available with the court. However, the same is not available in the case records today. Registry is directed to verify, to trace out the said affidavit objections stated to have been filed and connected to the case records. Mr. M. K. Sharma appears for the petitioner, who may file a reply in the meantime. There is no provision for reply. For filing a reply, is given 2 weeks time to complete his instructions in the matter of
6th or 7th of June, because thereafter again this vacation will come.
6th or 7th of June. Vacation starts in July. Vacation will start in July.
Exactly.
It will come 2 weeks. How much time do you require? 1 week?
2 weeks, madam, 2 weeks.
2 weeks. So it requires 2 weeks time.
And let's say we are date 17th or 18th.
List immediately after 2 weeks for hearing.
Because even if
MS
the senior council is 10 days, so if it's a fixed date, it is a little easy.
BS will learned counsel appears for the petitioner in item number. You are appearing for 39.
39.
Mr. M. K. Sharma for 40.
19th of June, subject to my last.
19th is a Monday. It can't be.
Sorry.
20. Yes, 20th of June, 20.
Yeah.
Based on 20. Yes.
I'm okay.
Item 42.
I'm for the respondent of it.
Yes.
But the matter may be adjourned for today, Lordship. I'm.
Okay. Petitioner is not there. You should have taken the opportunity.
If you may supposed to argue this matter, I have no impact to the.
You are Mr.
PHOD.
P.A.
PHOD.
P.A. Chaudhary, learned counsel appearing for the respondent submits the matter be adjourned for the day. None appears for the petitioner involved. Mr. P. Sharma appears for
Only sole respondent.
only sole respondent. Okay, list next week.
43.
None appears for the parties involved. Who appears for the state? There. Mr. B. Sharma appears for the state, none appears for the petitioners on call list next week.
Forty-five.
Yes.
This basically response number 1 million was represented by data. Security will be one complexity. After there is a direction to appoint amicus curiae member. But order dated 9/2/2023 method. So to direct it to appoint an amicus. The cleared for it. Then appeal letter second.
Amicus curiae list. No amicus appointed. Amicus has been appointed. What is the name? As per order dated 9/2/2023. Amicus curiae to assist the courts, to represent respondent number 1 has been appointed. Who however is not present in the matter is called up. Mr. Rayat Soikia appears for the petitioner. You are ready? We are not. We wanted to just know what is the matter. It's an NI matter. NI.
NI case, discharging the burden. Response number.
Discharging the burden of what?
The presumption is always in favor of the complainant.
Yes.
Who post the check. Check was issued by the response number 1 in favor of the petition. Appealant. He presented the check before the claim. It was dishonored due to insufficient funds. Thereafter, he filed his complaint petition. Complaint petition, he adduced evidence in his favor. The witnesses supported this case. But the response number 1, he himself, he was examining himself. None other has supported this case. And without rebuttal, this complaint petition was this case. There is a mandatory presumption in favor of the appellant. Complaint. Then also be relying on some petition from the court matter, wherein the court has held that particular place is debated.
Amicus phone number. We'll see if the amicus is available. We'll inform. Let us wait till the second half. It is there. It is there. These are here. That 2.
46.
None appears when the matter is called up. By order dated 28, none appears for the applicant when the matter is called up. Mr. B. Sharma appears for the respondent state. By order dated 28/03/2023, prayer of the earlier council, Mr. J. Ahmed, for withdrawal of his name as a advocate, for withdrawal of his wakalat was permitted. And in his place, Mr. S. Islam, who S. Islam appeared in the matter and submitted that he was the newly engaged advocate in the matter and sought some time to prepare the case. Accordingly, in the purely for the ends of justice, the matter stands adjourned for the day. List next week. Mr. B. Sharma appears for the petition. Sorry, state, respondent state.
Item 47.
Two o'clock.
Yes, after item number 38.
What is this? What is this item? What is this matter?
It's petition under section 376. And legal section 493 for NPC member.
Okay. Your madam appearing for the informant,
And number 2, I was the victim.
a victim. Will, sorry?
Okay, you'll be here. I'm not
Yes,
going to take it.
yes, yes. I'll take it up at 2 seconds.
Yes,
They want some time. Yes.
Forty-eight.
Conviction or conviction or already take place 36 for it. Next again.
Initial 8.
And actually, page 36.
Ah.
Order dated 27/9/2020. Last paragraph, I sentence Muhammad Babu Ali to suffer simple imprisonment for 7 years under section 4 of the POCSO Act. And also to pay a fine of ₹10,000 in default of fine. He will undergo simple imprisonment for 2 months, and in my view, it will meet the
You are going for the
Plus 1 hour 2
respondent 4,
Plus 1 hour 2
2 informant.
Information. So far instruction goes nothing. The guard, victim guard has already made.
So
So we have no objection with Lordship. Granted bail to the people.
who are you? Who are you?
I'm Meena Bora.
I know. How are you connected to the victim girl?
I'm a mother.
So as a mother, will you accept a conviction against your daughter by saying that she is married off? And you have no objection?
Already married, that is my right. Otherwise,
And married with whom? With the appellant? Married with the appellant?
not a.
Then?
Other person.
Then? Can it be disposed of on agreement?
No.
Then
Even
it's an appeal against a judgment convicting the appellant.
even the victim cannot compromise.
Exactly.
Mother not.
And you are a mother and you are agreeing that she is married off and therefore it should be closed. Anyway, yes, Mr.
Should we come to memo for appeal?
I think at 2, we'll begin at 2. We'll begin at 2.
For consideration of internet.
No, for hearing the appeal only. Why interrogatory? Why interrogatory? 2016 matter.
Yes.
Or you want only interrogatory?
That is it.
Interrogatory, we'll dismiss it.
Maybe hard in the required stage, but.
We'll dismiss it. Interrogatory. Were you on bail earlier?
No,
Previous bail? Were you on previous bail? Do you have the order?
I do not have the order.
Then?
Standard on 27/9/2022. That is the day of the meeting.
You get the order, we'll have it next week. Order on, or was he allowed to go on previous bail? Do you have that order?
I do not have that.
So you get that order. You get it by next week. List next week at the request of Mr. Bora. And enabling him to get the order. Granting the appellant, allowing the appellant to remain on previous bail. Which he submits, would like to place it before the court. Mr.
Yes, sir.
A. Sharma appears for the informant mother, and Mr. B. Sharma appears for the APP, state APP. List next week. Date, maybe one. You take a date from the court, master.
Okay. Six. अभी थोड़ा सा है थोड़ा सा है कुछ ना कुछ काम कर रहा है तो आदमी उसको क्या दायित्व नहीं है तो मारता है दूसरा संदर्भ में क्या कर लेगा अपन क्या कर लेंगे हेलो अरे कल कार्तिक क्यों से कार्तिक क्यों कल क्या होगा 22 तारीख का ऑर्डर देखो तो असल में वो तो नहीं है वो एकदम ब्लैंक अपना आप प्लीज নহয় আজি তাৰপিছত আমি টিভি দেখো
আমি 16 তারিখের অর্ডার এটা পড়ি আছে সবাই নাই তো 16 তারিখে জমা কালি পর্যন্ত পাইছে আর কোন স্যার একটু এই অর্ডার কো এখানে পড়ি আছে স্যার একটু অর্ডার করুন স্যার টিভি ফাইল করে দিলে তো কোন কি করি বলে না ভাই সকল করিব লাগবো সব তো বলেছেন সকল দিয়া বলে কারণ ও স্যার the record was pending for final correction. What is it? सारे मग बोले कधी मेरी किती जेते जेते फाइल तो आहे ते मग बोलू सारी मान फाइल मारत এটা দুটা ফাইল একটু নামতে না থাকে সব কিতে অ্যাক্টিভ হয়ে যায় ওই না তুমি ঘরত বই থাকা না এই কারণে কভার বলে স্যারের কাছে করে ঘরত না যাও ওই ইয়াতে থাকে ওয়াটি থেকে বলে হবে কাম করে বলে
Mr. Das,
I have given a second measurement. If the conviction is upheld, and if the or the lordship set aside the meaning will be the same. So I beg to call this condition to ensure that this.
so what had happened was there was this appeal filed against conviction. By the time this matter came up before the court, the sentence was already over. Now the question left was, Mr. Sharma suggested that it has become infractious. According to me, it has not. So it requires some decision in the matter. So we thought we'll seek your assistance, but now Mr. Das says that on instructions that he wants to withdraw the appeal. Is filed by the persons convicted.
No, but whether the appeal stands abated, because on the date only it stands abated. There cannot be any abatement of appeal. My appeal has to be brought to a logical conclusion.
That's
But
right.
now, since it was filed, whether one can withdraw it is not to be very easily seen.
So kindly,
Yeah, I'll
you examine and
give me a date, but I'll definitely look into it.
you can take your date. We are requesting Mr. Kamar to assist the court. You are also there. You will appear for the appellant, Mr. Sharma for the state. But considering a slightly peculiar situation, we are requesting Mr. Kamar to
Sure, man.
assist the court as an amicus curiae.
On 14, my lord. 14.
No, it could be
I
either,
use the code on the 14, my lord.
no, if possible on 13th or 15th, I mean Tuesday or Thursday, if you can.
13, I will be out of station, that's why.
Then 15th,
Sure, man. I'll.
15th is a Thursday.
Sure. Man. 15. We'll complete it. 7.
At the request of the court, Mr. Z. Kamar, the senior counsel, has appeared before this court, and the court would like to request Mr. Kamar to assist in these assistant amicus curiae in the matter. So Mr. Kamar has agreed to assist the court as an amicus in the matter. He, however, seeks a short date to apprise the court on the legal issues involved in the matter. Mr. B.C. Das, learned counsel, appears for the petitioner. Mr. P. Sharma, learned APP, appears for the state. Let the matter be listed again on 15th of June. Meanwhile, the courtmaster will arrange to furnish the adequate copies to the
Memo of appeal and the judgment, good enough.
to the learned amicus curiae. List accordingly on again on 15th. It will be on 15th of June.
15. That would be much over.
Yes, Mr. Zaki.
Inform me over telephone matter, say out of station for medical treatment of his father. See page for 2 weeks time.
Item number
45 minutes.
45. You submitted that the amicus curiae appointed by this court, MS D. Soikia, has informed the learned APP that she's out of station for medical treatment of her father. And accordingly, prays for accommodation for 2 weeks. Whereas Mr. I.S. Vakia, learned counsel, appears for the petitioner, does not object to the prayer made. Accordingly, let the matter be listed again after 2 weeks.
Right.
Will come after 2 weeks.
Possible the date will be fixed.
22nd.
Please step to item 47.
I would, my senior is lagging some other thing for time being.
40, 40,
47.
47.
49.
Yes, madam.
Begins the interrogatory order of announcement, my lord. The opposite party filing criminal revision before the learned session, the Halakan my lord. There is an interrogatory order passed under section 146, subsection 1 regarding attachment. My lord, the learned trial court, my lord, after hearing the parties on the basis of police inquiry report, my lord, and considering the emergency situation, after drawing of proceeding under section 145, he attached the disputed land and prohibiting entry of both the parties into the disputed land and directing the parties to adduce evidence with relevant documents as to fact of the possession. Against that order, my lord, the opposite party filed a petition before the trial court for negating the ex parte stay order. My lord, the learned trial court directed the circle officer to submit report which said that there is a dwelling house and shop, etc. But without awaiting that report, my lord, he filed a criminal revision before the learned session, the Hailakandi, my lord. The learned session, the Hailakandi, my lord, set aside the attachment order, my lord. The impugn order is, my lord, Elixir. Elixir 5 page 21. Here, what you will find, it is not a reason order. Here it is clearly stated there. Page, my lord, 24. Page 24, my lord, second line. An interlocutory order cannot be a subject matter to be challenged before a revisional court. But however, if the order affects the right of the parties, in that event, the same can be challenged before the revisional court. The revision petitioner has already appeared before the trial court for reconsideration of the attachment order and the order drawing up the proceeding against them. The question of title and ownership are the facts which should be decided after recording evidence of both the parties. The fact of possession of respective parties can be decided only after recording evidence by the learned trial court. It's a fact, my lord, question of right and title cannot be decided by the trial court, as because it is a proceeding under section 145 CRPC. The learned trial court can determine only the fact of possession. And in the order itself, it is final order, it is clearly written in the final order, we have seen in other cases also. Right and title is a different thing that can be ascertained by the civil court. Now, my lord, the attachment order, Annexure 2, page 14.
Yes.
Page 15. My lord, here.
Can you read the order? Read the-
Case record put up today in my file, since the complaint petition dated so along with affidavit, column number and photocopy of land documents duly filed by first party Sri Sandumia Loskor, son of resident of Valley, Safety, Bodapur district, Hailakandi, against Sri Zahirul Haq Loskor, son of and 4 others. also seen the inquiry report submitted by ASI, Hailakandi Police Station, which was duly forwarded by Inspector Officer in charge of Hailakandi Police Station of 25/4/22. Her to learned the lawyer for the first party petitioner at length. First party submitted a petition dated 26/4/22. As per police report, it appears that there is a land dispute in between both the parties. And both the parties are dangerous and desperate in nature and requested to restrain both the parties not to work on below mentioned scheduled land till decision of learned court to maintaining peace and tranquility. As per complaint petition, first party member stated that he is the lawful owner and possessor of scheduled land mentioned below by right of inheritance from his father and has been enjoying the said land without any obstruction. But recently, the second party members have illegally and forcefully trying to grab the scheduled lands by dispossessing the first party. The first party father already complained that the second party members are dangerous and desperate in nature and they threaten the first party member with dire consequences as such. There has been created an apprehension of breach of peace and tranquility between both the parties regarding taking critical position over the hidden plot of land mentioned below by the second party members. Under the above circumstances, I am satisfied to draw up a proceeding under section 145 CRPC 1973, requiring both the parties to appear in person in the court and file written statement on their claim over the land, along with their valid original land documents and adduce evidence in support of their claims. Further, considering the emergent situation arising in the locality for taking physical possession of the land by the second party members, there is every possibility of group clashes between both the parties and other breach of public peace and tranquility in that locality. Hence, in view of the above situation and being satisfied, I do hereby invoke the provision of under section 146 subsection 1 of CRPC and attach the disputed land as mentioned below and prohibits entry of any parties till further orders for maintaining of peace and public tranquility in the locality. The order is given ex parte considering the urgency of the situation. Both parties to appear at the next day fixed for hearing and filing objection. The officer in charge Hailakandi Police Station is directed to maintain peace and tranquility in the locality and execute the order that is attachment that attach the disputed land below after observing all formalities as per provision of law and furnish the factual report of the disputed land schedule mentioned below on or before the next date fixed. And copies of this order is served to both the parties to appear before the undersigned on the next date fixed at the fixing the date 24/4/22. Therefore, my lord, the annexure 3, my lord, the respondent filed a petition, my lord. Stating
Where is the inquiry report?
inquiry for annexure 1, police inquiry report. Annexure 1, my lord, the brief, page 14, the brief of the case is that I have made locally inquiry about the fact of the petition and found that there is land dispute in both the parties. Both the parties are very desperate and danger in nature. So both parties may kindly be ordered not to work more on the disputed land to keep peace and tranquility. Under the above facts circumstances, I pray to your honor to restrain both the parties not to work on below mentioned land till decision of court. Party will produce witness before the court when called for sufficient paper and period. I love the very purpose of drawing up a proceeding under section 145 and my lord attachment of disputed land under section 146 is to prohibit entry of both the parties into the disputed land, directing the parties to adduce evidence with relevant documents, written statement, etc. to prove their fact of possession, my lord. My lord, that is purely interlocutory order, preliminary order, my lord, and that is a temporary order that may be changed by the trial court, my lord, after taking the evidence, etc. Now, my lord, they filed a petition annexure 3 for getting ex parte order. Page 17. And annexure 4 is the order on the basis of that petition. Court passed order, my lord. The annexure 4, page 20.
No, which order?
My lord,
Page 21 order.
my lord, they filed a petition. On that petition, my lord,
Which order was passed? Page 21.
In extra court, in that order, my lord, the trial court simply stated that the circle officer Hailakani Revenue Circle is requested to depute LR staff to cause an inquiry about the present status of the scheduled land mentioned below and submit a factual report along with sketch map, copy of Dwamani, if any, and land documents earliest to reveal the actual possession of the said land before the next case. So, my lord, without awaiting the date of that report, my lord, the opposite party responded filed a criminal revision before the session judge. So, my lord, my respectful submission will be, my lord, since it is purely interlocutory order. So, my lord, the order passed by the learned session judge, that may kindly be set aside, and directing the parties to appear before the court below to decide the matter after taking evidence with relevant document, etc. My lord, in this respect, my lord, the petitioner filed a title suit and he subsequently, the title suit has been withdrawn, my lord.
Why did you file the title suit?
My lord, the document has come to my hand, my lord.
Yes.
This
So basically, the sessions judge has remanded the matter back, but after interference.
my lord, that attachment order has been withdrawn, my lord, since the order passed by the learned trial court, my lord.
What is that land for? Is it cultivable land?
Yes, my lord.
Yes.
My lord, my respect to some submission is that the matter will be remanded to the original court, my lord, to decide on the basis of the relevant documents and evidence, etc., my lord, to submit the written statement by both the parties. The trial court, my lord, has not committed any wrong, my lord.
But why did the trial court prevent both parties?
Trial court, my lord.
On what basis?
File the attachment or.
Not trial court, the district magistrate.
My lord,
The order of attachment was passed by the district magistrate.
yes, ADM.
So on what basis did it come to a finding that you are the lawful owner and possessor?
My lord, the petitioner before lordship is the lawful owner.
On
and
what
possessor
basis?
of the mentioned will by right of inheritance.
No, what, do we have any documents to that effect?
My lord, at present, we have to note as
If you
document.
come to page number 15,
Yes,
you'll find third paragraph. Third paragraph,
as per complaint.
as per complaint.
First party member.
First party means the petitioner here,
Yes, he is the lawful owner.
lawful owner and possessor. So on,
mentioned below by right of inheritance from his father and has been enjoying the said land without any obstruction. But
So-
recently the.
so on the submission which you made
Yes,
before the district magistrate, was it on the basis of some documents or title deeds to show any document available here?
but I didn't take instruction on this point, but the here, my lord, in the order itself, it is stated that, my lord, page 16, my lord,
Hmm.
further, third paragraph, hence in view of the above situation and being satisfied, I do hereby invoke the provision under section 146, subsection 1, share and attach the disputed land
Correct,
section
correct,
below and
correct.
prohibit entry of parties till further orders maintaining peace and public tranquility. And my lord, in first paragraph.
How are you benefited by this order?
My lord, it
It is your land.
yeah,
At third paragraph, you say you are the lawful owner, possessor, right of inheritance, and you have been enjoying the said land without any obstruction, meaning you are already in possession. You've stated that.
yeah.
Now, if both parties are prevented from entering by this interim order, how are you benefited? You are not allowed to enter.
No, both parties are prohibited.
So how does it,
That's why-
how does it benefit you?
No, my lord, that attachment order may kindly be remain in force in the final disposal of the case.
But it doesn't benefit you because you claim this is your land.
Yeah.
You are not allowed to enter and you want that order to remain.
That's why, my lord, at page 16, first paragraph, it is stated that under the above facts and circumstances, I am satisfied to draw up a proceeding under section 145 CRPC.
You are not answering the question of the court. You say this is your land, default upon you through inheritance under your possession, you're enjoying that plot of land, and you say it is a cultivable land. Now somebody else has tried to encroach, some petition one has been filed under this is 145. So the court, the district magistrate passes an order preventing both parties,
Requiring both parties to appear.
including you,
Yes,
but
yes.
you claim to be the owner of the land.
Yes.
So how does it benefit
So,
you?
so my attachment order may kindly be kept in abeyance in the final decision of the court as to the fact of possession.
So the session judge has already directed that both parties should go and a fresh decision be taken on the basis of the.
My lord, if the attachment order is not in force, then my lord, at any moment they may dispose me, my lord. That order.
You
may
cannot
kindly be
enter,
in force,
you
my
cannot enter in by virtue of this order.
Yes, my lord.
Then where is the question of dispossessing?
Yes, my lord, I do admit, my lord, the
No.
prohibiting entry of both the parties.
Exactly.
That may kindly be kept in abeyance in the final decision of the trial court, my lord, as to fact of possession, as because another.
The question before the session judge is ordinarily in an interlocutory order, no revision lies. But if the rights are affected, so the session court is of the view that the claim made by you perhaps, according to the session court, doesn't appear to be correct. Therefore, the order of the district magistrate is interfered with and a fresh decision is directed to be called for.
Yeah.
Now, you say that this land belongs to you, you are in possession, matter is under your control, and you have been enjoying without obstruction. Now, first party wants to forcibly grab it, second party.
Yeah.
And the district magistrate passes an order prohibiting both parties,
Yes.
including you,
Yes.
not to enter. Then how does it benefit you?
Well, till the final decision of.
So when is the decision likely to take place? When was this order passed? When was this order passed?
Well, this order passed on, my lord, 27,
One-
22.
One year has gone by, and you have not been able to get up on this land.
Matter may be remanded to the original court and the order passed by the learned district magistrate, that is 27/4/22, that may kindly be kept in force, my lord. That's because otherwise, my lord, there is no.
No,
possibility
unless you satisfy us that yes, you were actually in possession. It is possible that somebody else was in possession, they were in possession. You filed this case and prevented them from being in possession.
No, my lord, now the question is, since the proceeding is started under section 145 as to fact of possession, my lord, that's why the learned trial court prohibited the entry of both the parties, my lord. Since the question of fact of possession is to be decided under section 145, so my respectful submission would be, that order may be kept in abeyance, and my lord, both the parties may adduce evidence.
Where is the sessions court order? 21,
Yes,
page 21.
yes.
There are one criminal division. He says he has a residential house on the disputed land, opposite party. They say they have a residential house.
That's why, my lord, the learned trial court, my lord, directed the circle officer to submit report, but without awaiting that report, my lord, the respondent filed this criminal revision, my lord. My lord, that is, my lord, the order, annex of 4, page 20, my lord. Annex of 4, page 20, this clearly stated. They have residential house, they have shop, this, that. And sometimes one part may be cultivable and one part may be residential, and that may be so. So, my lord, they said that they have residential house, they have shop. That's why, my lord, the trial magistrate passed an order asking the report from the seller staff to cause an inquiry and submit a report. But they should have awaited the report submitted by the, to be submitted by the circle officer, but without awaiting, my lord, he directly approached the learned session judge, and learned session judge says that question of right and title involved. Question of title, right and title doesn't involve under section 145 proceeding. It is purely the fact of possession. The trial under section 145, the trial magistrate can only decide fact of possession. not question of title.
Yes, Mr. Council, what do you submit?
Yes, my lord. With humble respect to my senior counsel. Some of the relevant documents is suppressed in filing this petition, my lord. The most relevant is the complaint petition, my lord. It was filed before the district magistrate, my lord. I have annexed, my lord. Where they have admitted that we are in possession. Page number 52 of my reply, my lord. By the reply, I have annexed the petition. And that is intentionally, my lord, not brought on record by filing the petition. Page number 52, my lord. Admitted that we are in possession, though there are some.
No, look at paragraph 53. Page 53,
Yes, my lord.
first para.
First, my lord.
Kindly read that first
No
part.
reply to that. No reply. Yes, it is.
53 would be the continuous page. This will be the second page
Yes,
of the of your reply.
my reply. My lord. Yes, continuous page. From second paragraph of 53, may I read?
Yes.
Yes. The petitioner Artfield, the eastern.
No, before that, before that.
Before the first party is the lawful owner.
Then who is the first party?
Yes, sir. First party, it is her claim. He is the lawful.
No, no, you are stating that.
The first party, my lord, it is, my lord, their petition, my lord.
It is their petition.
Their,
Oh,
before the, my lord, district magistrate.
okay, oh, sorry, yes,
My lord, it has not filed along with this division petition.
all right.
So
So,
I have a next, my lord.
but where did they say that you are in possession?
Yes, my lord. May I read, my lord, from next page, my lord. From the next paragraph, the petitioner Artfield, the easternmost part of the civil mentioned land, which are trust the PWD road purpose construction soap house nearest south next middle of the schedule below mentioned dwelling house, my lord, and go down of the second parties, we are, my lord, orally entered into an agreement and started business promising that they will be entered into written agreement shortly. However, all the second parties, although first times gives regularly monthly rent of rupees 800 per room per monthly 2000, but from second parties elapsed giving date after date and now totally refuse to give monthly rent. Moreover, first party when intend to make extension of stock houses as well as go down room on 23 Artfield into the western part of the city below mentioned land, then second party raised their strong objection, trying to, while he started to actually, we raised objection, my lord, we are in possession, admitted, their case. First party from schedule below mentioned land with malified intention of grabbing the first party schedule below mentioned land into, but by the intervention of the local people, the very purpose of the second party become in vain. That now all the second parties are trying to grab the first party's land by dispossessing, trying to grab my lord, and just as there is every possibility for breach of the peace. So this is the petition, my lord, though it is a false, my lord, and fabricated story that we are his tenants, my lord. My lord, for the sake of my lord argument, if it is, my lord, admitted that we are tenants, my lord, then we are in possession, my lord, of the dwelling house, my lord. So, while the admitted solution is the dwelling position, but actual fact is that, my lord, I have annexed the sale deeds, my lord. The disputed land we have purchased, my lord, I have annexed.
Who filed the title suit? By the petitioner,
Yeah, my lord, this is another aspect, my lord.
but then you withdrew.
Civil
Then
dispute.
we do, my lord. With liberty.
This is the suit, my lord, they filed, my lord. We do not have any. So, my lord, regarding this case, my lord, there is nothing to be decided regarding possession because it is admittedly that we are in possession, my lord. 145 proceeding, my lord, for only for the decision of the possession who are in possession of the suit, my lord. And my lord, the Lionel District Magistrate, my lord, passed the order, your lordship, has already introduced the order, on the basis of the inquiry report only, my lord. In the inquiry.
This is an interim order.
Yes, sir, inquiry report is silent, my lord.
Inquiry, no, inquiry report it says that there is likely to be disturbance.
But my lord,
That is the whole purpose of this section.
my lord, that should be the basis of, inquiry should be basis for the regarding the possession, my lord. It is-
What possession? It's a question under. PRPC. Yes,
140.
145, 146.
Yes.
Hmm, yes.
Procedure have disputes concerning land or water is likely to cause
Breach of peace.
Whenever an executive magistrate is satisfied from a report of a police officer upon other information that a dispute likely to cause a breach of the peace, at least concerning any land or water or the boundaries thereof within his local jurisdiction, he shall make an order in writing and stating the grounds of his being so satisfied and requiring the parties concerned with such dispute to attend his court in person or by pleader on a specified date and time and to put in written statement of their respective claims as they respect the fact of the actual possession of the subject of dispute.
Hmm.
So the actual possession matter already it is admitted matter we are in actual possession matter.
It will be decided after evidence.
Kindly come to the
Next matter.
subsection 4.
The magistrate shall then, without reference to the merits or claims of any of the parties to the right to possess the subject of dispute, peruse the statement so put in. So while no statement is recorded, my lord.
Written
No
statement has not been submitted.
No statement, my lord. Here the parties, no hearing, my lord.
No, that is the whole purpose. The parties were directed to appear and file.
Yes, my lord.
Yeah.
But my lord, what situation has, my lord?
On the basis of the police report, that is what subsection 1 says.
But it is a mechanical report, my lord.
Whatever it is a police report. The section permits the magistrate to pass appropriate orders on the basis of a police report.
Yes. My lord,
So whether the report is exhaustive or superficial, you'll have to urge before the court, before the magistrate.
yes, my lord.
That has not been done.
Not been done, my lord, but
The session court has also not given a finding that the report is absolutely superficial, doesn't say anything.
yes, my lord. If I read my lord, the whole judgment is not written, the impugned order may I read, my lord, for the session that, my lord.
Yes.
That will be there. Page 121. The petition. The initial division between the between filed and that challenging the impugned order is so and so passed by the APM, within the invitation was so and so. We leave the learned trial court committed error in law, so to integrity that impugned order is improper and the same was irreparable loss to the revision petitioner. That the revision petitioner has his residential house on the disputed land, that the learned court below failed to appreciate the fact that the dispute purely civil in nature and therefore there is no apprehension of breach of peace. With the revision petition is paid for, I have heard the submission to the learned counsel for the revision petition submits that the impugner is not sustainable in view of the fact that he is actually owner of the land on the strength of purchase and the impugned order also has been passed ex parte without hearing the revision petitioner, as there is no apprehension of breach of public peace and tranquility in the concerned area, the impugned order is liable to be set aside. On the other hand, the land counsel for the first party office submitted that the impugned order is an interlocutory order and the court is yet to finally decide the matter. The routine order was passed after obtaining police report from the concerned police station and the interim order needs no interference.
You come to para 5 straight away,
Yes.
only on the basis,
Yes, no doubt the.
no, below that.
Only on the basis of police report.
Hmm.
The learned trial court should not have passed the expertise.
Why? Because the section permits,
My lord, section.
there is no finding,
Yes, section is section permits, my lord,
then.
but will part 146, my lord, we will have to go to 146, my lord. The there should be the satisfaction of the emergency, my lord, emergency situation, my lord. May I go
It
to
is an
146?
interlocutory order.
Yes, my lord.
You are entitled, you have already filed an application for vacating this order ex parte.
Yes,
There was some report called for.
yes,
Now, what is the status? We do not know.
yes.
You have come before the revision court
My lord,
against that order.
my lord, that is right, my lord.
Hmm.
But my lord, may I humbly submit the prerequisite, the conditions on which the attachment order is passed, my lord.
Hmm.
My lord, 146 may I read, my lord.
Yes.
140 power to attach subject of dispute and to appoint the receiver. If the magistrate at any time after making the order under subsection 1 of the Joint Act considers the case to be one of emergency. That what is.
No, this is emergency or.
Or yes, or my lord, but this order is passed on emergency.
No, there is another one.
Yes,
Kindly come below
or
that.
if he decides that none of the parties was then in circulation. This is the second one.
Hmm. Or.
As such referred into particular, or if he is unable to satisfy
Hmm.
himself as to which of them was then in possession of the subject of dispute.
So there are three instances.
Three instances.
So
So regarding second.
perusal of the order reveals that it is the third instance on the basis of which he has passed the order.
That instance should be after trial, because that.
Now, where do you read that in the section?
What if he is unable to satisfy himself as to which of them is was there in possession of subject of dispute.
Hmm.
To decide who is in possession, my lord. There should.
No.
Yes, sir. The third is, or he is unable to satisfy. Your lord.
He is unable to satisfy. That is why he has asked both parties to appear and file statements.
No, my lord.
Both parties claim we are in possession. Therefore, he says you come and file objections. Meanwhile, don't enter.
My lord, their own complaint says they might admit that we are in possession.
No, it does not. It
Yes,
does
sir.
not.
Yes,
You have
sir,
not been able to.
The complaint.
No. He says you are a tenant.
Yeah, that is I am in possession.
Then.
Tenant means I am in
No.
possession, my lord.
You are a tenant and you have not paid the rent, etc., etc.
Yes, my lord.
That's a different issue. That's not.
So, my-
You are saying that you had purchased this land or something.
Yes, my lord. In fact, my lord,
Yeah.
we have purchased, my lord.
Then
Yeah.
that makes you an owner, not a tenant.
Yes, but my lord, for the sake of argument, my lord, if they are right, that we are tenant, my lord, and admittedly we are in possession, my lord.
We are not convinced with your arguments.
My lord, their complaint petition itself, my lord.
We are, this is to be decided by the magistrate.
Yes, my lord, but my lord, for the purpose of my lord, passing the attachment order, where the respondents, my lord, living with their family, my lord. The children, the school going children are there, my lord. That property, my lord, they also admitted, my lord, that it is a residential plot, my lord. Dwelling place, they admitted, my lord. Such, we are inside the house, my lord, living, my lord. House.
Is there any interim order?
Yes, my lord, interim order is passed by this honorable court. The operation of the session court is state, my lord. So, my lord, my humble submission will be before the honorable court, my lord.
You go back. We are disposing of this criminal petition.
My lord, this petition will also remand back, my lord. The attachment order, my lord, this honorable court, my lord, may.
We will direct the magistrate to decide this matter within a period of 30 days.
Yes.
Until then, the interim order will remain passed by this court.
Parties may be directed
My
to
lord,
appear.
it will cause a very difficult situation. my lord.
Why? You are
Why,
already.
my lord? Because the residential house.
No, I agree, but this court has already passed a stay order on 39/2022.
Yeah.
So where have you been residing there?
Still they are residing inside the house. my lord.
Inside the house,
Yes, my lord, they are residing.
in spite of this interim order.
My lord,
The order of the session court is suspended.
yes, my lord.
And that means the other
Where to go, my lord, the with his family, my lord, children is there, my lord. The land documents is there, my lord. Yes.
I heard MS Pidas level counsel for the petitioner, PDB level counsel for petitioner, and Mr. MJ Khadir, another counsel hearing for the respondent. Opposite party also. This criminal revision petition is filed by the petitioner, praying for setting aside and quashing the judgment dated 2007-2022. Passed in Criminal Revision 42 of 2022. Passed by the Court of Session Judge Hailakandi. The brief facts in the relating to the present proceedings are as under. The petitioner, who claims to be the owner of a plot of land, approached the Court of Additional District Magistrate Hailakandi by filing an application under section invoking the powers under section 145 and 146(1) of the CRPC. Also, the said application was registered as case number 148N of 2022. Also, by order dated 27/04/2022, the district magistrate, additional district magistrate Hailakandi, issued the following order. Is explained. Then, pursuant to this order, the opposite party filed a miss case, being miss case number 148 of 2022, seeking to vacate the ex parte order dated 27/04/2022, passed by the district magistrate, directing for attachment of the disputed land. Also, in the same petition, what order was passed there in the stay vacating? In the same petition filed by the opposite party seeking vacation of the ex parte order, the additional district magistrate by the order dated 24/05/2022 directed the circle officer Hailakandi Revenue Circle to depute LR staff and cause inquiry about the present status of the scheduled land mentioned therein and submit a factual report along with a sketch map, copy of Jamabandi, if any, and land documents at the earliest, to reveal the actual possessor of the land before the next date fixed. Also, the OC Hailakandi Police Station was directed to serve a copy of the order to both parties to appear before the court on the next date fixed. Also, the opposite party thereafter approached the Court of Sessions by filing criminal division number 42 of 2022. Also, the Court of Sessions by the order dated 2007/2022 allowed the criminal petition, interfering with the order of attachment passed by the additional district magistrate, and remanded the matter back to decide the matter afresh after giving opportunities to both parties of the heart. Also, the Sessions Court came to a finding that the district magistrate, while passing the order dated 27/04/2022, relied only on the police report. Also, being agreed, the present revision petition has been filed. Learned counsel for the petitioner submits that the petitioners are the actual owners and possessors of the land, and they have inherited the said plot of land from their late father, and has been enjoying on the said land without any encumbrances, full stop. However, the opposite party attempted to encroach the said land and created a dangerous situation, because of which the petitioners had to approach the additional district magistrate for passing necessary orders under section 145 and 146 of the CRPC. Also, the counsel for the petitioner submits that there is no infirmity in the order dated 27/4/2022 passed by the learned district magistrate. And the said order is an interlocutory order, leaving both parties to appear on the next date by filing objections. Also, the learned counsel for the petitioner submits that the said order was passed on the basis of a police report submitted before the magistrate. Also, learned counsel for the petitioner further submits that his said order was being an ex parte order, an application was filed for vacating the ex parte order by the opposite party, being this case number 148 of 2022. Also, in the same case, the additional district magistrate Hailakandi directed the circle officer, Hailakandi Revenue Circle, to depute LR staff for inquiry of the scheduled land and submit a factual report along with the sketch methods, copy of Jamabandi, etc., so that the actual possessor of the land can be identified by the next date fixed. Also, it is submitted that without allowing the district magistrate to proceed in the matter and pass appropriate orders on the basis of such inquiries made and documents that may have been filed, the petitioner approached the Court of Sessions Judge, the Court of Sessions, Hailakandi, by filing a revision petition. Also, it is submitted that the order having been passed as an ex parte or an interlocutory, ex parte interlocutory order, revision petition is not maintainable against an ex parte order under section so and so CRPC. Also, accordingly, the impugned order should be interfered with, set aside and quashed, and the matter be remanded back with the matter be remanded back, and the order dated 27/04/2022 passed by the additional district magistrate be restored. Mr. M.J. Karthik, learned counsel appearing for the opposite party, however, strongly disputes the submissions made by the learned counsel for the petition. We submit.
Yes, the emergency is regarding the regarding that the emergency word itself should not may not be sufficient for passing the word. Paragraph 9 may not count. Paragraph 1. 2004, 263 my lord. Paragraph number 9. Regarding emergency may
Paragraph?
9.
Yes.
If the word itself should not be sufficient my lord, for passing the word. It may be noted, paragraph 9. The section 45 of the court together proceed a claim for resolution of the situation where likelihood of breach of peace, and section 146 should not be separated from 145, and it can only be read with context of 145. From the provision of section 146 as reproduced above, it becomes obvious that attachment can be made by learned SPM or executive magistrate. 1. The magistrate considers the case of emergency. 2. The magistrate finds that none of the parties was in possession as referred in 145. 3. The magistrate is unable to satisfy himself as to which of the contending parties was in possession of the subject of dispute. The scheme of the act clearly contemplates that before attachment is made under either of the past two circumstances envisaged, the magistrate must produce the evidences produced before him, including a written statement of the party. It is only after he finds that none of the parties was in possession of the disputed land, or after he is unable to satisfy himself as to which of the contending parties was in possession of the subject of dispute, that the magistrate has the jurisdiction to pass an order of attachment, and in that eventuality, the order of attachment will be operative if the rights of parties thereto are determined by a competent court. Hence, in this case, we are concerned with an order for appropriately passed under the first circumstance contemplated. The circumstances under which such power should be invoked may be examined. Since attachment of property has the effect of causing serious inconvenience and prejudice to at least one of the parties, such emergency measure should be taken only in exceptional cases, and an attachment should not almost as a rule follow an order under section 1 of 146.
You are reading from which paragraph?
My paragraph 9
Oh.
of the minorities, the Sophie,
Yes.
Sophie Ali.
Yes, yes.
Yes, brother. The second part of the paragraph. Since in this case, we are concerned with an order probably passed under first circumstances contemplated emergency, my lordship. The circumstance under which such power could be invoked may be examined. Since attachment of property has the effect of causing serious inconvenience and prejudice to at least one of the parties, such emergency measure should be taken only in exceptional cases.
Is this an ex parte order?
Yes, my lord.
Where do we find it?
The petition finding is regarding an ex parte order.
Finding.
The finding is regarding ex parte order. May complete with that reading the paragraph.
Yes, yes.
I complete. Such emergency measure should be.
If you wanted to rely on the judgment, why didn't you rely on it immediately after you completed your arguments? You are relying in them. Now we are in the middle of dictating the order.
Let me complete this part.
Under section 145 and 146.
Let him complete first.
Let me complete.
Let him complete first. Please take your seat. We will give you an opportunity of arguing.
Such emergency measures should be taken only in exceptional cases, and attachment should not be used as a rule of law and order under section 1 of 146. Ordinarily, an order of attachment should be made after hearing the parties to be affected by the order of attachment, and only in rare and exceptional circumstances the magistrate should pass an ex parte order of the attachment after already indicating how, in the interest of maintenance of peace, an ex parte order of attachment was necessary, and where insistence of proper service of notice to the parties may be dispensed with. It may be noted that the existence of the ingredients necessary for passing an order under 145(1) CRPC would not automatically attract the provision of 146(1) for attachment of property. Therefore, the magistrate must satisfy himself as to whether emergency exists in spite of the order under 145(1) of the code before he passes an order of attachment under section 146 of the code. The word emergency maintained in section 146(1) of the code contemplates the situation completely different from one in which there is apprehension of breach of peace. Madam, the inquiry officer, the police officer in the inquiry report mentioned apprehension of breach of peace, madam, which is one of the basic legal necessities for initiating a proceeding under 145. Is necessary, madam, for initiating a proceeding, madam. The fact that ordinarily the situation has arisen is not enough. Mechanical reproduction of certain terms as used in the statute cannot justify a finding unless there are materials in support of it. But there should be some material that some injuries or some attack, one part attack, another part, nothing is there, madam, in the report. No materials.
So, but in a given situation,
Yes.
where the district magistrate is seized of the local conditions, if there is a disturbance, what is he supposed to do?
Madam,
What are the remedies available? What are the powers available to prevent?
Yes, madam. If the inquiry report, madam, reflect any such.
Inquiry will not happen within one day.
The police report, madam, there is a police report.
There's a police report. Police report reveals that there are dangerous people, some clashes are going to take place.
Madam, apprehension, madam. There is apprehension of nothing is there.
I'm asking you a question. You are saying that there must be a satisfaction that it is an emergency
Situation.
or so and so is in the possession. That satisfaction will come only after filing of objections. That will come only after filing of objections.
Madam, that may come from the report also, madam, the police report, madam.
The police report says that there is going to be clashes.
Yes.
You are saying this is not a police report or this is not a detailed police report.
Yes, madam.
So under those circumstances,
Yes.
what is the power under section 145 or 146?
Yes, so that is there, my lord.
Then
That is there for three conditions there. But this judgment, my lord, it is clear that there must be something, my lord, where the using of the word emergency or my lord, the apprehension of breaches, it is not, my lord, sufficient to pass an expert email attachment.
when the report says that imminent, that the clashes are likely to take place, is it not a situation for emergency? What more satisfaction? How elaborately is it to be? How elaborately is it to be described in the police report?
There is nothing that anything happened, my lord, or anything, nothing is mentioned, my lord.
Where is the police report again?
Yeah, my lord. Page number, my lord, 14, 1-4.
1-4.
1-4. Party will produce.
Very desperate and danger in nature.
Words mentioned, my lord. Kindly, my lord, the witness, my lord, column number 6, my lord. Kindly, column number 6, my lord.
Yes.
Party will produce, my lord. If the police has gone to the spot, my lord, some persons should, my lord, certify that these persons are, my lord, disparate persons, dangerous persons. Nothing is mentioned, my lord. So the party will, my lord, produce the witness, my lord. How they came to the conclusion, my lord, that the parties are dangerous persons, my lord. There must be some person present in the spot, my lord. They must report that they are dangerous persons, disparate persons. My lord, this is important, my lord, very.
But which is why you have filed the vacating petition.
Yes.
What has happened to that?
My lord, that was, my lord,
That is still pending.
pending, my lord.
Then you have filed the vacating petition.
Yes, that was pending.
At your instance, it was filed.
Yes.
The parties were given liberty to reduce the evidence or file objections.
Yes.
The report of the so-and-so was called for.
Yes.
Before that, any order could be passed, you approach the sessions court and the matter was, this aspect was in place before the sessions court.
Yes.
The fact that
Yes,
you,
the order mentioned, my lord.
Is it mentioned?
Pending, yes, mentioned.
then,
Mentioned. But because of the, my lord, since it is a residential dwelling house, my lord, the respondent is living, my lord. Page number 21, my lord, is mentioned, my lord. Petition is pending. Due to the, my lord, for emergency vacating the order, my lord, the respondent has treatment. And admittedly, my lord, the respondents herein are in possession of a dwelling house, my lord. In such a situation, my lord, only mechanical report of the police, my lord, the because residential house is because
On what basis you are making this claim again,
which
that you have a residential house?
my lord,
What is your
it is my lord,
supporting evidence,
it is my lord,
documents?
they are admitted fact in the petition my lord, before the district magistrate, my lord. Before the district magistrate, they are petition. my
You
lord, they-
say that you have a residential house.
Yes, my lord.
So you must produce something before in support of your.
Yes, my lord, in my reply, my lord. In my reply, my lord, I have annexed the documents, my lord.
Hmm.
Yes, my lord, page number 48, my reply, I have annexed the documents, page number 48. Page number 48, my lord, 49, onwards, my lord. Kindly peruse, my lord. My reply,
Page number,
48, 49, my lord.
yes.
Electricity connection, my lord, 49. No objection regarding, my lord, my construction of the residential building, my lord, page number 48. This is the no objection before construction of the house, my lord, I have taken. The variable of loss per meter, the concerned government NOC given. After construction, my page number 49 is the connection of the electricity, my lord. I have taken connection of electricity on August 21 in my residential house. Page number 50 is a type copy, my lord, 51. I have taken the electricity connection. Then, my lord, there is a 51 is an loan sanction letter, my lord. I am a teacher by profession, my lord. I have taken a loan, my lord. Personal my advance loan for constructing 13,77,000 to construct the house, my lord.
Hmm.
These are the, my lord, proof of, my lord, my residence in the city.
Yes. Madam, do you want to submit any more?
My lord,
There are judgments referred to.
my lord, that is not applicable as because, my lord, when the enforcement order is passed by the trial court, during any stage of proceeding, if he is satisfied that there is no apprehension of peace or tranquility, etc., he may modify or amend the order, my lord. So, being satisfied, the learned trial court may have passed this
You
order.
go through this order.
My lord,
You go through this order.
that copy is not given to me, but I have heard.
He is not supposed to come to your aid. You are supposed to come back. Come with all your arms and ammunitions. Why will he give you that copy? You take a copy from the court master will give you the citation. You can take a copy.
Copy of my-
You take the citation from the court master. You will get a copy. We'll take it up tomorrow.
Probably one Thursday, madam. One Thursday.
Thursday, okay. Thursday. At the request of Learned Council, the miss, and so it will be listed on Thursday. Thursday. No, Thursday.
Item number 47.
Item 46, my lord.
Hmm.
Item 46 is in mentioned next week, my lord, and then date will be fixed, my lord. The address, my lord.
What is 46?
Appeal against equitable convention, my lord.
Give a date, 46. Hmm.
Appeal against conviction. The appeal has been convicted and that's before.
No, which matter you are arguing? This matter?
46.
Matter. 46 will come next week.
Next week, my lord.
Next week.
Date will be fixed, my lord.
Yes, give a date, 46. When the matter was called up, you know,
It's a given effort.
you take a date from the court master.
8 June. 8. Plus.
Yes.
My lord, no respect. My lord, the sentence is, my lord, 7 years, my lord, for 376,
Hmm.
and 5 years for 493. But to be at the outset, my lord, I'll come to the assignment. At the outset, my lord, they cannot go concurrently conviction under both sections of law because it has to be cognate offenses, my lord, possibly lots of authorities there. My lord, I'll come to that. Now, here, my lord, with all respect, my lord, several witnesses are examining even the PW1, my lord, the prosecutive day, that regarding 376, the conviction cannot sustain. Because allegedly she was raped on 2 occasions, my lord. But my lord, those are contradictions and proved before the eye. And in the judgment, my lord, the learned trial court, my lord, it did not, in its judgment, my lord, did not mention that those were contradictions. I'll come to that, my lord. May I just read the entire once, my lord? That is at page, my lord, before the rest of the paper book, my lord. Page 4, my lord.
Page 4.
Page, yes. May I read it? I'm putting emphasis on 4 years of relationship, Michael. With due respect, I beg to submit that about 4 years ago, she Mintu Pharma so tricked me into falling in love with him with a fake promise to marry me and rape me thereafter. As he raped me, I became pregnant twice. See, Mintu Pharma forcibly got my fetus aborted twice by doctors and kept deceiving me by telling me continuously that he would take me to his house. Later, I myself went to the house of my husband, in the month that means married, my lord. Month of June last.
Husband means she was married.
As per her, this is the affair, my lord, content of affair. 3 different versions in 3 different ways. After my arrival at my husband's house, my conjugal life ran peacefully. Meaning thereby they were married to each other, my lord. As per the affair, my lord. For some days, and thereafter my mother-in-law and husband, she Mintu Pharma, kept issuing threats to me and asked me to leave their house. They used to torture me daily, both physically and mentally, and demanded a cash of rupees 5 lakhs from my parental home. They also threatened me that they would kill me if their demand was not made. I therefore pray to you to take necessary steps in this regard by looking into the matter and oblige. From here, if we visualize, my lord, they were married to each other, my lord. And my lord, no dates are given regarding commission of rape, my lord, with all respect. No specific dates, my lord, as to commission of rape, my lord, with all respect, my lord. Now,
Is it necessary to give dates?
There are some authorities to there, but that is not necessary in the extent. Now, my lord, with all respect, my lord, may I read the 164, I will come to the evidence. That is at page 93, my lord. Yes. Now, this is 164 of the CRPC, my lord. One Mintu Pharma visited my house at Tongla with a proposal to marry me. He cut his finger and put his blood on my forehead, assuring that he will marry me. Gradually, Mintu Pharma started to visit my house and I started to have forceful sexual intercourse with me. I became pregnant twice and he took me to Momalway Polyclinic for abortion. He kept on delaying the marriage every time. On 5 June 2018, I visited his house at Hozara Park, and after a discussion with family members and villagers, it was decided that our court marriage will be performed within 3 days. But Mintu Pharma caught hold of my neck and tried to kill me. Subsequently, parents of Mintu Pharma started to torture me. Now Mintu Pharma is saying that he will not marry me, and his parents are also against the marriage. He forcefully had sexual intercourse with me several times. Now, my lord, if the both are raped conjointly, my lord, with all respect, my lord, FIR is as regards fulfillment of marriage, my lord. Here it's a different story and some development regarding putting vermilion, my lord. And thereafter, my lord, with all respect, my lord.
Not vermilion, blood, is it?
Oh, I am sorry. I'm sorry, my lord, not vermilion, blood. Furthermore, my lord. My lord, to be precise, my lord, regarding framing of charge, my lord, Lordship will kindly have a look at page 6. Charges were framed under section 420, my lord, because omitting to marry or not marrying, my lord. Acquitted, my lord. Then 376, convicted for 7 years. I'm sorry, my lord, page 6. 420, charge was framed, my lord. Acquitted, my lord. 376, convicted for 7 years, my lord. And my lord, 330, acquitted, my lord. To be precise, my lord, charge was never framed under 493 of the Indian Penal Code.
Okay.
To be precise, my lord, if charge is not framed, my lord, what is the difficulty for the defense, my lord? He cannot prepare his defense, my lord. Have I made my point? If charge is not framed under section 493, I cannot cross-examine him. Taking, my lord, with all respect, visualizing the existence of 493 while cross-examining the witnesses, my lord.
Where is the FIR again?
FIR, my lord, with all respect, my lord, page 4. Very.
No, I just wanted to see what are these sections. 420, 376,
330.
330. So,
Whatever the police did put, my lord, with all respect, my lord, charges were
framed.
framed exactly on the same counts.
Now, which particular section you said no charges were framed?
493, my lord, convicted thereafter, my lord.
Oh.
And sir, my lord, to be precise, 216 of the Code of Criminal Procedure, my lord, with all respect, my lord, it can be altered at any point of time, even prior, 1 day prior to the date of judgment. Even that has not been carried out, my lord. Thereby depriving me of the opportunity of cross-examining the witnesses, my lord, visualizing the existence of, my lord, with all respect, my lord, section 493 of the IPC. But then that cannot be done. And my lord, with all respect, my lord.
Where is the judgment?
Yes, my lord. That I'll come, my lord, also to kindly have a look at
The judgment with in respect of this 493
exactly, my lord.
portion in respect of
Yes, my lord. Yes, my lord. 493 portion. Page 86, page 87, my lord. Para 60, my lord. Lordship has found, my lord. From the above, it follows the prosecution is successful to bring home the charges under section 376, 493 IPC against the accused, whereas the charges under section 420 IPC has no legs to stand. Thereafter, my lord, I turn back, my lord, revert back to para 57, that is at page 86. Married, my lord.
Yes.
Here in this case, during charge framing, the fact of committing sexual relation with the victim on several occasions with a promise to marriage, and thereby she became pregnant, has been clearly mentioned that during the course of evidence. Also, the accused had the opportunity to cross-examine the prosecution witness on the fact that he pretended to be the husband of the victim. So this is not there, but this is absolutely a misnomer, my lord. Committed sexual intercourse with the victim because charge was not paid. So the accused has been aware of the basic ingredients of the offense of, well, this cannot be visualized in this manner, my lord. The law is very clear because charge can be altered under section 416 of the Code of Criminal Procedure even 1 day prior to pronouncement of judgment, my lord. And he got fair chance to defend. No, this cannot be, my lord. Mayor, I think
No, it can be altered, and then he'll have to be given an opportunity.
Exactly. From the beginning itself, my lord. From the time of framing of charge, my lord. We don't. All witnesses will be recalled, my lord, on that count, my lord, with all respect, my lord. 217 CRPC, my lord. With all respect, my lord. And as such, this is no circumstance emerging the failure of justice. My lord, this is illogical. I should not say, my lord. This is this much, my lord. I read the next paragraph, my lord. With all respect. And 58, my lord. In view of the discussion of the evidence on record, it appears that the accused maintained physical relationship with the victim, not only by pretending to be a husband, but also there is evidence on record that he put blood on the head of the victim as a mark of marriage. And since thereafter the victim used the vermilion on her forehead as a mark of marriage with the accused. The victim also in her evidence stated that the accused used to scold her. The victim also in her evidence stated that the accused used to scold her if she does not put vermilion on her forehead. And the same piece of evidence of the victim remained unrebutted. So all ingredients of offense punishable under section 493 IPC is satisfied here in this case. Hence, the decision relied upon by the learned counsel, except so and so, so and so, so and so. My lord, so if 58 is taken into account, there has to be some evidence as to lawful marriage. Even that is missing. Now, my lord, these parts of the judgment, my lord, with all respect, my lord, can I take?
Yes, yes.
My lord, here, my lord, the law is very clear, my lord. My lord, section 3, you convicted me without framing charge under section 493, 5 years. At the same time, you convicted me for 376 IPC. I'll read the evidence, my lord, regarding 376 on both the dates, my lord, total contradictions put before the eye. Now, my lord, 493 will sustain, my lord. Then I'll wait, my lord, because I'm reading this, my lord, in my understanding, my lord, let me put it in this manner, my lord. There has to be cognate, my lord, with all respect, my lord. In a case, my lord, wherein, my lord, charge is paid under section 325. If, my lord, medical report comes not under 325, he can be convicted under section, sorry, my lord, if 326 is there, my lord, with all respect, my lord, charge has been framed. He can be convicted if the medical report comes otherwise subsequently, my lord, for 323, 324, 320, whatever be it, my lord, with all respect, my lord. It has to be cognate offences, my lord, and minor offences, my lord. Here he has convicted me for the higher degree offence, my lord, 376, and also convicted me for my lesser degree offence of 493, my lord. But the law does not visualize it, my lord. It has to be cognate offences, my lord. May I just well, can I just read the authority at this time?
We'll go to the authority.
Oh, I'm sorry.
Now, I think court has also dealt with the fact that no charges were framed under 493.
But that is exactly, court has dealt with, but it has to be dealt with in accordance with law.
Absolutely.
My lord, he cannot create law, my lord.
So
He has to create law as it is there in the statute or by some authority.
how is it being dealt with? How is it being dealt
Yes,
with?
my lord. My lord, page 85, para 56, my lord.
Yes. Para 55, I think it begins.
55, my lord.
Yes.
Fact remains that no charge under section 493 IPC has been framed here in this case. So a question may arise whether without framing a formal charge under section 493 IPC, one can be convicted under the same section of personal law. In the case of Dalveer Singh versus Uttar Pradesh versus so the Honorable Supreme Court laid down the law as follows. There are a catena of decisions of this court on the same lines, and it is not necessary to burden the judgment by making reference to each one of them. Therefore, in view of section 464 CRPC, it is possible for the appellate or revisional court to convict an accused for an appellate or revisional court to convict an accused for an offence for which no charge was paid, unless the court is of the opinion that a failure of justice would in fact occasion. Yes, failure of justice, because I never visualized the existence of 493 while cross-examining. In order to judge whether a failure of justice has been occasioned, it will be relevant to examine whether the accused was aware of the basic ingredients of the offence for which he is being convicted, and whether the main fact sought to be established against him were explained to him clearly. My lord, that was my lord in different tenor. Here, my lord, the circumstances are different, my lord. In this case, my lord, which he has quoted, my lord, out of context, there are the sections of law where 302 and 304B. Have I made my position clear, my lord? And my lord, thereafter conviction was granted under section 306 IPC, my lord. So, my lord, the tenor is different, context is different, textual matrix is different. And 306 is, my lord, with all respect, my lord, part of 30 cognate offense, my lord. 304B, my lord. Because that has to be even if by suicide, my lord, within 7 years of marriage, my lord. Where, my lord, instead of 306, my lord, 304B would be affected, my lord. Have I made my position clear, my lord? With all respect, my lord. Thereafter, my lord, whether the main facts sought to be established against him were explained. This is not the case here, my lord. To him clearly, and whether he got a fair chance to defend himself. We are therefore of the opinion that so and so, so and so, so and so. So and so was not correctly decided as it purports to lay down as a principle of law that here the accused charged under section 302 IPC, he cannot be convicted for the offense under section 306 IPC. My lord, that's not the case here, my lord, with all respect, my lord. Now, my lord, this is my lord as regards my lord, lordship's query, my lord. How he dealt with it, my lord, without framing charge as regards my lord, with all respect, my lord, 493 IPC. My lord.
Yes.
493 IPC. My lord. Now regarding 376, my lord, with all respect, my lord. Page 83, my lord.
Before
Lordship, kindly turn the case-
before that, can we go through 464, section 464?
Yes, yes.
CRPC.
Yes. Four 64, effect of omission to frame or absence of or error in charge. No finding, sentence or order of a court of competent jurisdiction shall be deemed invalid, merely on the ground that no charge was framed or on the ground of any error, omission or irregularity in the charge, including any misjoinder of charge, unless in the opinion of the Court of Appeal, confirmation or revision, a failure of justice has in fact been occasioned thereby. 2. If the Court of Appeal confirmation or revision is of opinion that a failure of justice had in fact been occasioned, it may, in a case of omission to frame charge, order that a charge be framed and that the trial be recommended from the point immediately after the framing of charge. In the case of an error, omission or irregularity in the charge, direct a new trial to be had upon a charge being framed in whatever manner it thinks fit, provided if the court is of the opinion that the facts of the case are such that no valid charge could be preferred against the accused in respect of the facts to itself was the conviction. Now, my lord, I'll come to that if the necessity arises. Now, my lord, to be precise, my lord, if I read in totality also, my lord, no iota of evidence as regards lawful marriage. See, you wanted 3 different concerns, my lord. I read the 164, I read the affair, and I'll now read the, my lord, with all respect, my lord, the evidence. When that is missing, my lord, you cannot out of the blue bring in, my lord, and quote a particular authority, my lord. There being no parallelity can be drawn between the two, my lord. And thereafter, my lord, convicting, my lord, that is possibly not in a consonance with law. But this has to be read with, my lord, with all respect, my lord. First of all, with 222, can I just?
Yes.
At 222 CRPC. And it is very, my lord, the illustrations are very clear. Even authorities of this fund are very clear, my lord. Regarding, my lord, if 302, my lord, there is a case in a 302, my lord, with all respect, my lord. In that event, my lord, for a lesser degree of offense, my lord, he can be convicted for, my lord, 304 part 1 or part 2, my lord, not otherwise. It has to be lesser degree, but cognate offenses, my lord, with all respect, my lord. And cognate has been well defined, not in the code, my lord, my lord, with all respect, my lord, judicial lexicon, my lord. My lord, now, my lord, I am reading, my lord, 222, my lord. Where offenses, lordship has found, my lord.
Yes.
Where offenses proved included in offenses charge. When a person is charged with an offense consisting of several particulars, a combination of some only of which constitutes a complete minor offense. Have I made my position clear, my lord? Because the law is specific. If you are to, my lord, convict me for a lesser offense, not parallelly, my lord. My major offense and minor offense together, my lord. But if materials are not found regarding the major offense, then for a lesser offense, my lord, with all respect, my lord. This is very clear, my lord, intention of the legislation, my lord. Some only of which constitutes a complete minor offense, and that has to be complete, my lord. And such combination is proved, but the remaining particulars are not proved. He may be convicted of the minor offense. My lord, 493 in this regard.
Malab, they must have the same ingredients or parallel ingredients, my lord. Similar ingredients, my lord, that will come, my lord. Though he was not charged with it. Have I made my question clear, my lord? Here we are not charged with it, my lord. He could have done it. Had it been a case of 406, in place of 406, he convicted me for 420 without framing charge under section 420. Malab, that even the illustration is to that effect. I'll come to that, my lord. May I just read it wholly, my lord. When a person is charged with an offense and facts are proved which reduce it to a minor offense, he may be convicted of the minor offense, although he is not charged with it. This is not the situation here, my lord. Malad, it could be, my lord, here, my lord, in a given case, in this situation, my lord, he could have convicted me, my lord, with all respect, my lord, for attempt to commit rape, my lord. My lord, lesser offense, my lord, with all respect, my lord. Taking this view into, my lord, this law into perspective, my lord.
What is
Then three, my lord.
what according to you is a cognate offense with
Yes,
regard to
cognate
376?
Yes,
You are convicted under 376.
511, my lord.
511, all right. Now, in the absence of any charges being framed under section 493, which according to you is not a cognate offense,
Yes,
just for the debate,
my lord.
what offense is according
Here
to
there is
you?
no cognate offense.
You mean to say
It
that?
will come, my lord.
Hmm.
It will come, my lord, promising to marry, not marrying, it will be 470.
Hmm.
Maximum. And 470 is, my lord, extend to 1 year. Instead of 470, he brought in, my lord, 493. If I read it,
Yes.
because rape is gone, my lord. So rape is gone, and with the evidence, my lord, contradictions to even before the IR. By following the due process of law.
No, now you are convicted under what? 376.
You convict me for 370.
376 you are convicted.
Yes, my lord, 7 years.
7 years.
And thereafter 493 together.
Hmm. Hmm.
There it is.
Yes.
My lord, with all respect, my lord. When a person is charged with an offense, he may be convicted of an attempt to commit. This is there, my lord. Can you see, my lord? When a person is charged with an offense, he may be convicted of an attempt to commit such offense.
You are reading which section? Which section?
222, my lord. Subclause 3.
Yes.
Exactly, my lord, it came out from my mind. It is there itself, the statute itself, my lord. When a person is charged with an offense, he may be convicted of an attempt to commit such offense, although the attempt is not separately charged. My lord, with all respect, my lord. Thereafter, 4. Nothing in this section shall be deemed to authorize a conviction of any minor offense, where the conditions requisite for the initiation of proceedings in respect of that minor offense have not been satisfied. My lord, the intention of the legislation was clear, so this section was inserted. The statute is apparently crystal clear. What he could not have done it, he did it in an oblique manner. Now let us come to the illustrations, my lord. Illustrations should possibly, my lord. They are very clear, my lord. May I read it, my lord?
Yes.
A is charged under section 407 of the Indian Penal Code with criminal breach of trust in respect of property entrusted to him as a carrier. It appears that he did not commit criminal breach of trust under section 406 of that code in respect of the property, but that it was not entrusted to him as a carrier. He may be convicted of criminal breach of trust under the same section 406. Thereafter, A is charged under section 325 of the Indian Penal Code while causing grievous. He proves that he acted on grave and sudden provocation. He may be convicted under section 335 of this code. These are the illustrations. With all respect. This is 222, my lord. Well, now, my lord, I'll come, my lord, possibly that query would remain, my lord. Again, my lord, to drive on the point, my lord, that if you convict me for the higher degree of offense, 376, despite there being no evidence, that's a different matter, my lord. You convicted me for 376. Have I made my question clear, my lord? And thereafter, you convicted me for the lesser degree of offense, although the ingredients are not categorized in the same category. That is not the mandate of law. He could not have done it, he cannot do it.
That is not the mandate of law, my lord. Now, my lord, with all respect, my lord. Can I come? to
Yes, yes.
Can I come to the evidence? And only I show that part, my lord, that she was released twice. And my lord, it was not told to the IO and my lord proved before the IO. Not even kindly will. Page 8, my lord. PW1 victim, my lord. Other witnesses are not very material, my lord.
Yes.
When she is the victim, my lord, prosecuted. Page 8, my lord. Leaving aside 3 lines from the top, my lord. I am reading the entirety, my lord. 5-6 lines, my lord. I am the informant. I lost the affair against me to Sorma. Incident occurred in the year 2016. My marriage was arranged with the accused prior to 6 March 2016. On 6 March 2016, on the occasion of Fakua, accused visited our house. I was in the house alone. Our family members went to the temple for offering puja. The accused was under the influence of liquor. The accused, after entering into the house, locked the door from inside and held my hand and took me inside the room and forcibly raped me. I cried. My lord, this part, my lord. My lord, this is absolute rape, my lord. My lord, with all respect, in evidence in my lord, chief, my lord. With all respect, my lord. Thereafter, my lord. PW9, my lord. The investigating officer, my lord. Page 28, my lord, second paragraph. My lord.
Yes.
I read the second paragraph, my lord. Victim did not state in her statement given to me that on 6 March 2016, on the occasion of Fakua, accused visited our house. I was in the house alone. Other family members went to temple for offering puja. The accused was under the influence of liquor. The accused, after entering into the house, locked the door from inside and held my hand, took me inside the room and forcibly raped me. I cried. Victim did not state in her statement. That means this is an improvement, and that too, my lord, in 161 it was not there.
He is the IO.
IO. So that means it is gone, my lord. First allegation of rape, my lord. Am I clear, my lord? Perfectly, my lord, state check and clear, my lord, with all respect, my lord. Rape was never committed because never stated before the investigating officer under section 161, my lord. And it was an improvement, my lord, with all respect, my lord, during in chief, my lord, while giving evidence, my lord. Now the second incident of rape, my lord, I am turning. And my lord, if I read 2-3 lines, the page 8, my lord, that itself is unthinkable, my lord. Can you see, my lord, after committing rape, I cried. Lordship has seen, my lord, page 8, my lord. It was denied by the IO that the statement was made by the lady while deposing under section 161. My lord, then I cried that part, my lord, with all respect, my lord. Thereafter, my lord, then the accused stuck his finger by blade and put blood on my foot. It is, my lord, I don't know, my lord, incongruity, my lord. After commission of rape, my lord, which is denied that she made the statement, that's a different story, my lord. My lord, this is not, my lord, with all respect, consistent, my lord. Is it possible, my lord? I commit rape, then I cut my finger and my lord put like Vermilion, my lord, that I think I have married her. So this is her statement, my lord, with all respect, my lord.
It may not be impossible always.
My lord, I don't know, my lord, I have just read it. And thereafter, my lord, the second allegation of rape, my lord. I will not go beyond it with all respect, my lord. Page 10, my lord. Page 10, my lord. Leaving aside 9th line, my lord. 9th line, my lord. On the previous day of his lordship is from, my lord.
Yes.
On the previous day of his living, in the evening, while I was inside the toilet, the accused forcibly entered into the toilet and raped me. This is also an allegation of rape, my lord, with all respect, my lord. The second allegation, my lord, with all respect, my lord. Then when I come to the IO, my lord. In 161, she never stated that, my lord. So he could not have convicted me under section 376, my lord. Page 29, my lord. Let me begin from page 28, my lord. This is the investigating officer, my lord. Lordship, the last paragraph, my lord, with all respect, my lord. Last paragraph, my lord. During investigation, I did not examine so and so the victim's statement before me that they stayed in the house of victim for about 6 days. Victim, this is very important, my lord. This is I'm putting emphasis, my lord. Victim did not state in a statement given to me that on query about the accused, it goes on and on, my lord. Then there comes the left part in the same paragraph, my lord, page 21. Page 21, married, my lord. The left part is denied, my lord. In 161, she never stated. Accused did not turn up on various requests in the
Page, paragraph.
Same paragraph, my lord, same paragraph.
Page 21.
Page 28, page 29, my lord. Beginning line, my lord.
Yes.
My lord, with all respect, my lord. Accused did not turn up on various requests, but at the half line, my lord, in the evening. On the previous day of his leaving, that I read the cheat, my lord. On the previous day of his leaving, in the evening, while I was inside the toilet, the accused forcibly entered in the toilet and raped me. But victim did not stay. In 161, he did not. This is an improvement. With all respect, my lord, put before the IO. So rape is gone, my lord. And how he convicted me for 376, and this regarding this part, my lord, he never discussed in the judgment matter. I read it out before your lordships, my lord. I read it out those paragraphs, my lord, with all respect, my lord. As he brought in, my lord, 376. 376 is totally gone, my lord. So now question comes, my lord, how he can convict me under section, my lord, with all respect, my lord. 493. First of all, my lord, let us visualize, my lord, FIR, my lord, full marriage. 164, little bit different story. And here, my lord, she entered the house, stayed as husband and wife, but she was giving out to that effect, my lord, evidence, my lord, with all respect, my lord. Am I correct, my lord?
Yes, carry on.
Yeah. But now they are after, my lord. Okay. My lord, first of all, my lord, my lord, as my lord, I'll place some authorities regarding commission of rape, my lord, in a relationship, my lord, because 4 years constant, my lord, with all respect, my lord. My lord, prior to that, my lord, may I read, my lord, that in a lesser degree of offense, my lord, if it is not a cognate offense, my lord, with all respect, my lord, without failing charge, he cannot do that, my lord, with all respect. Let me read that authority first, my lord.
Yes.
My lord, with all respect, my lord, 2001, 2 SCC, it goes on and on, my lord. Thereafter, my lord. My lord, lordship, I am putting emphasis on para 16, my lord. Lordship has found it, my lord.
Yes.
Para 16, my lord. What is mean by a minor offense? My lord, reading with 222 together, my lord. Section 222 CRPC, my lord. It talks about minor offense, my lord. For the purpose of section 222 of the code, question mark, my lord. Although the said expression is not defined in the code, it can be discerned from the context that the test of minor offense is not merely that the prescribed punishment is less than the major offense. Less than the major, because major offense will be 376, wherein you have convicted me for 376, there being no evidence as regard 376. And my lord, with all respect, my lord, 493 IPC, my lord, lesser degree of offense, but that would not satisfy, my lord, the legal necessity, my lord. The two illustrations provided in the section would bring the above point home well. Only if the two offenses are cognate offenses, my lord. With all respect, my lord, cognate offense is not defined in the code, my lord. With all respect, my lord. May I, what is code? To Should I place it together, my lord?
Yes, it's well. What
That is
does,
before-
what does black say?
My lord, my lord, my lord. My lord, cognate offense towards the left towards the corner, my lord.
Left,
At the bottom, my lord.
sorry,
Go ahead. At the bottom left corner, my lord. Cognate of lordship is found.
yes.
My lord, cognate offense.
Hmm.
A lesser offense that is related to the greater offense.
Hmm.
My lord, here, my lord, with rare. My lord, with all respect, my lord, deceiving a lady with the promise of marriage, they don't fall in the same category, my lord.
Hmm.
It could have been, my lord, promising to marry and not marrying, my lord, or whatever be it, my lord, deceiving, my lord, 470, or my lord, 376, 511, my lord. As is there in the contained in the some subsection of 222, I guess. CRPC, my lord. I read it out before your lordships, my lord. With all respect, my lord, as is said, a lesser offense that is related to the greater offense, because it shares several of the elements of the elements of the greater offense. No, 493 and 376. Greater offense. And is of the same class or category. I'll not go beyond this one. Have I made my position clear, my lord?
Hmm.
Incongruous, man. It cannot happen, man. Incongruous, man. 493 clubbing together 376, and my lord, despite the mandate of 222, my lord, you convict me without evidence for the higher degree of offense and for a lesser degree of offense. That too, they don't, my lord, birds are not birds of the same feather, that they flock together. My lord.
Hmm.
Again, I am reading, my lord, with all respect and full hands, my lord, cognate offense, a lesser offense that is related to the greater offense. They must be related to each other, my lord, because it shares several of the elements of the greater offense.
Hmm.
Assuming, my lord, it is permissible under law to punish one under section 376, and at the same time with 493.
How do you say 493 and 376 are not cognate?
Because 376, that force has to be there, my lord.
Hmm.
In case of, my lord, with all respect, my lord, deceiving a lady that I am married to you, force is not necessary.
Hmm.
No, my lord, it has to be, my lord. Rape, my lord, force is
375, there is an element of consent.
yes, my lord.
So anything you do without consent
Yes.
can be construed, can be brought within the parameters of 375.
My lord, yeah, that I agree. My lord, regarding marital, my lord, is defined nowadays, my lord.
Hmm.
375, fourthly, my lord. With her consent. Have I made my question clear, my lord? Meaning there was a wife. With her, fourthly, with her consent.
You're reading 493,
No, 375.
375, so. Yes.
Not wife's consent, my lord, victim's consent.
Hmm.
Fourthly, with her consent, sorry.
Yes.
With her consent, when a man knows that he is not her husband, and that her consent is given because she believes that he is another man to whom.
You are reading 493,
No, 375.
375, yes.
Fourthly, my lord.
Fourthly, yes,
Married,
with her consent,
married, my lord.
yes.
Meaning there was a victim, my lord, with all respect, my lord.
Hmm.
Tailor made, my lord. Fourthly, with her consent, if the man knows that he is not her husband, and that her consent is given because she believes that he is another man to whom she is or believes herself to be lawfully married. These ingredients are not there because she says, I am not married. Have I made my question clear? I am not married. Parents stopped me from getting married or whatever be the reason. And now if I read 493 conjointly, my lord, it would be everything would be, my lord. No iota of doubt, my lord, with all respect.
What would be an example relating to the fourth situation?
Fourth, my lord.
What would be an example?
Is it that I should not go?
No. What I'm saying is, what what you are trying to say is the lady identifies the person, the accused, to be somebody else.
That is all, isn't it?
Sorry,
Somebody else, sorry.
somebody else.
No, mate. Somebody else.
Yes.
Yes.
She believes
That
he is another man
Oh.
to whom she is married,
Exactly.
when the man is actually not that person.
Exactly. Well, 493, if I read together, my lord.
Yes.
Totally, with her consent, meaning thereby the consent of the lady. In the instant, first of all, my lord, let us visualize the situation. FRC says married, my lord. Have I made my question clear, my lord? Married. In 164, little bit different. In evidence, he says, my lord, with all respect, my lord. She was ravished, and she, despite being promising to marry her, he did not marry her. Am I correct, my lord? How, my lord, with all respect, trustworthy, my lord, starting point here, evidence is, my lord, that's why, my lord, with all respect, my lord, that has to be taken into account first, my lord, with all respect, my lord. And for, my lord, with all respect, my lord, first of all, rape is gone, my lord. The evidence part of it, my lord, with all respect, my lord. The rape is gone, my lord. That rape is there, rape remains, no, my lord. The 7-year offense is gone, my lord. Now, my lord, reading 48 as per your lordship's query, with her consent, the lady gives a victim gives her consent when the man knows that he is not her husband. It is up to the man, my lord, nothing to do with the lady, my lord. With all respect, my lord. And that her consent is given because she believes that he is another man to whom she is or believe herself to be lawfully married. She must have a belief that she is married to that man, my lord, with all respect. Am I correct? Here, this is not the situation, my lord. So I cannot be brought in, with all respect, my lord, whatever be the evidence in the instant case, my lord, with all respect, my lord.
Why not 2 and 3, secondly and thirdly?
2, my lord. Without her consent. My lord, the rape is gone. First of all, the evidence has to be taken into account. The evidence in 161, she did not say that she was ravished. She developed it during trial, my lord, because
Is there no any medical evidence? When the incident took place over a period of time.
4 years, that time of. And my lord, there are several authorities, my lord, on 4 years, my lord, even it is squashed. Relationship, alleging rape, my lord, with all respect, my lord, Apex Court has squashed it because of the quantum. Even in a case of 1.5 years of relationship, my lord, that 376, my lord, with all respect, my lord, FIR was. Now, my lord, with all respect, my lord, what I want, my lord, leaving aside everything, my lord. 376, she alleges on 2 occasions she was ravished in evidence. In 161, she
So
did not say.
your argument in a nutshell is without 376 being there, because the evidence does not support it, without you, the trial court would not have convicted you under 376 in the absence of any evidence,
Exactly.
to that effect.
Yes.
Now, without there being any evidence, there was no scope to further convict you under 493 when there are no charges framed.
That is what, prior to that, my lord, law does not allow him to do that.
Because it is not cognate.
Because it is to, first of all, my lord, whatever there is in the statute, my lord, which is the CRPC, is the Bible, Gita, Quran for everyone, my lord, for the litigant. And my lord, first of all, in a case can be visualized, my lord. When evidence is taken, my lord, say I am a trial lawyer, my lord, with all respect and folded hands, my lord, how do I begin, my lord? First of all, the chance has to be there, my lord. Otherwise, I will be carried away, my lord. Without there being the charge, my lord, I cannot cross-examine, my lord. Have I made my position clear, my lord? In some authorities, my lord, so remand that back, my lord. Have I made my position clear? But here is a case Here is the factual matrix is, my lord, with all respect and tolerance, my lord. Ingredients of 376 are not there because there is no qualitative evidence. Not to talk of qualitative evidence, my lord, there is no evidence as such. Because it was a development. Because in 161, first of all, she should have disclosed it before the investigating officer. It is a denial by the investigating officer, meaning there is a development during evidence, my lord. So when 376 is gone, my lord, he could have convicted me for under section 470. Lesser degree, my lord. But he could have convicted or could not have convicted. There has to be evidence first, my lord. Evidence is missing. And thereafter, my lord, evidence regarding 493 absolutely missing. How can you do that? If I read 493, my lord. May read 493 once.
Yes, yes.
$493, my lord. With all respect. First slide will, my lord, demolish the prosecution story, my lord. Prosecution permanent.
Yes.
Every man who by disease causes only a man who is not lawfully married to him. I will not go beyond this, my lord. Kindly see, my lord. First information report, they are married, my lord. Have I made my question clear, my lord?
Yes.
And 164 little bit different. And evidence is what, my lord? Marriage has not taken place. She is intending to marry her, he is refusing to marry this lady. Have I made my question clear, my lord? Because of parental pressure, my lord. And how come there has to be first of all, my lord, the evidence is to be, my lord, it must fall within the category of the ingredients of 493, my lord. And what 493 says, my lord, every man who by deceit, where is the deceit, my lord? She herself says, marriage is not complete, I am intending to marry her, he is refusing to marry me because of parental pressure or whatever be it, my lord. Have I made my question clear, my lord? When the ingredients are missing, and on the top of it, my lord, when you have convicted me for no evidence, that's a different matter. Under section 376, you convict me for an offense which is not a cognate offense under section 493 I see. That cannot be done, my lord. That will be, my lord, taking the law for a right. With all respect and for the next, my lord. Yeah.
Yes.
With all respect, regarding 370, here there is no evidence, my lord. But despite there being no evidence, my lord, even if there is evidence, had there been some evidence, my lord, because of the relationship, my lord, 4 years it is accepted by all, my lord. 4 years of relationship.
This is in regard to 376.
376, my lord. My lord, with all respect, my lord.
Yes.
First one is Udoy, my lord, that is 2003, my lord. There, my lord, I am reading, my lord, with all respect, my lord.
Yes.
There are 21, there are 21.
Yes.
Married, my lord.
Yes.
It therefore appears that the consensus of judicial opinion is in favor of the view that the consent given by the prosecutors to sexual intercourse with a person with whom she is deeply in love on a promise that he would marry her, same, my lord, on a later date cannot be said to be given under a misconception of fact. This much, my lord. Thereafter, same case, my lord. There are 25. My lord, I have given a dot there, my lord.
You have given a
Dot, my lord. We have marked my some lines down below. There are 25. My
on the contrary.
my lord, may I just read it, my lord? It was a little bit lengthy, my lord. On the contrary, the circumstances of the case tend to support the conclusion that the appellant had reason to believe that the consent given by the prosecutors was the result of their deep love for each other. It is not disputed that they were deeply in love. There is a relationship for 4 years in the instant case. Of course, there is no evidence of that, my lord. That's a different story. They met often because he came to my house, stayed there for 2 months. It does not appear that the prosecutors permitted him the liberties which, if at all, are significant that the prosecutors still went out. This is a different, little bit different background.
My lord, permitted only to a person with whom one is in deep love. This is good enough, my lord. Because she is in relationship for 4 years, she came on her own volition to the house, stayed there for months, as per her, my lord. Have I made my question clear, my lord?
Yes.
So if I, this much, my lord, with all respect, my lord. And following this, my lord.
You give us an authority as to the effect of statements not made under 161 initially during investigation cannot be relied upon as evidence. It may seem very elementary for you.
No, I'm not saying it like that. I'm not saying it. It is there in 145, 144.
Correct.
That is the law.
But you give us an authority if you can. Yes, what are the other judgments? Other judgments?
Tomorrow we can give.
Tomorrow, not tomorrow. Thursday. Thursday.
But my lord, we all respect, my lord. What is not there in 160, knows more than me, my lord. What is not there in 161, my lord.
No, we know if you have an authority as a matter of example, it becomes
Yes,
easier to refer.
yes.
Right.
Well, based on this authority, my lord, based on this authority, that my lord, some years of relationship, my lord.
Yes.
But I put one authority is there.
Yes, I have seen that.
No,
Yes.
my lord. Can I lift the page?
Certainly, certainly.
My lord, with all respect, my lord. There are 14, my lord.
Yes. Consent.
My lord, thus the law is very clear that a simple promise to marry without anything more will not give rise to the misconception of fact within parentheses, my lord. Within the meaning of section 90 IPC, in the instant case the victim claimed that the present petitioner proposed to her to marry and she had accepted the proposal. That is why she had gone with him. The victim girl had already attained sufficient maturity at a relevant time of occurrence. Now the court has reason to hold that the victim girl was a consenting party to the act of the present petition. Of course, here is no my lord, such sex attributed as per evidence instruction. We will give an authority to that. And my lord, there is another authority 2019. This before your lordship, there are 4, my lord.
Yes.
With all respect, my lord. In the fact and circumstances of the present case, it is difficult to sustain that the charges leveled against the appellants who may have possibly made a false promise of marriage to the complainant. It may be present in the instant case also. It is, however, difficult to hold sexual intercourse in the course of a relationship which has continued for 8 years, in our case 4 years, as rape, especially in the face of complainant's own allegation that they live together as man and wife. Same, my lord. And secondly, my lord, 1.5 years, and that was passed. This is 2021 SCC online. My lord, all other Sonu alias Subhash Kumar, state of Uttar Pradesh. They are, my lord.
There are 9.
Para 8, my lord.
8.
Para 8. With all respect, my lord. Married it, my lord.
Yes.
The contents of the FIR, as well as the statement under section 164 CRPC, leave no manner of doubt that on the basis of the allegation as a stand, there is important features emerge. Number 1, the relationship between the appellant and the respondent was of a consensual nature. Same is the case here, my lord. The parties were in relationship for about a period of 1.5 years. 1.5 years, my lord. Here it is 4 years, my lord. The double the period as is here in the instant case. Subsequently, the appellant has expressed this inclination to marry the second respondent, which led to the registration of the affair. Here also one of the affair was lost because of non-marrying. We don't understand here it was quashed. Not to talk of my lord taking evidence. It was my that is to be rendered. Para 11. So my lord, we face it. And 1 year already in custody.
Okay. Yes.
Right.
You want to give some more judgments?
No, actually, lordship said, my lord.
That's okay. Okay. What on Thursday?
Any day, my lord.
Yes.
Land senior council, giving my observations, my lord. My lord, go to the report, my lord.
Yeah, please do.
Evidence part.
Yes.
PW is the main person. my lord.
No, you begin your arguments once you complete.
Fine, fine,
Let him
fine,
complete his
fine,
argument.
fine,
Yes.
fine.
You are assisting the learned deputy. All right. Third, learned councils for the parties. List on Thursday for further hearing.
Right.
First,
My lord.
or can we have it on sixth? Sixth,
Oh, six should be better than that.
six.
My, I didn't.
We have Hardy. So we don't want to write Hardy in part,
Right.
but you can point out before if it goes before any other. So it is.
Item 50,
Itu sabun lagi tu, so logo rakhi begitu. Yes,
This I filed for the suspension of Ragman and order dated 7/9/2024. Passed by the assistant judge second judge Kardialong and convicted for 10 years.
where you want previous bail,
No, because I mean,
and then how many years? When was it,
For,
when were you convicted?
from 7/9/2020. About 8 months.
You have filed your objections.
Yes, Madam.
What do you say?
Yes, Madam. FIR is test 14.
Hmm.
Let the contradiction because in evidence and 164. Test 14, Madam.
When was the judgment delivered?
On 7/9/2020.
22.
Yes.
Yes.
May I read, please?
Page number
Test 14,
14.
next one.
Yes.
I have the honor to state that at about 3:30 PM on 02/05/2016, my parents and elder brother went to show danger at the hill and while I was alone in the house. The person Pamiram Tagbi by name of village Tagbigau came with a gun in his hand, committed rape on me by making threat and leg. I immediately went to the place where my parents were doing agricultural works and informed them about the incident. Then my parents and elder brother, with the assistance of the public, made an inquiry and could learn that the accused is a resident of village Sikari Takbi apart, and consequently the lodging of this SR got delayed. My lord, now my lord, 164 statement. This is my lord, page 42. In excerpt 4. May I read? My name is Mila Sunar. I am age 19. My house is at village Gangajang, Hirabasti. My father's name is Ratna Bahadur Sunar. My mother's name is Son. My elder brother's name is Nor Bahadur Sunar. My younger brother's name is Saras Sunar. My elder sister's name is Parmaya Sunar. And my another elder sister's name is Kumari Sunar. Both of my elder sisters have been married off. I read up class 2 in an LP school at Koilajang. Presently, I do nothing. I reside with my parents. On 2nd May 2016, while I was alone in the house, a boy came and committed rape on me by putting me under threat by showing gun. At that time, my parents and elder brother went to the house of my elder sister, Kumari Sunar at Gangajang Basti to show ginger. It takes about 20-25 minutes to go to the house of my elder sister from our house. At that time, I was washing rice and the door was open. The boy entered the house through the front door, held me on the ground by holding my hands, forbade me to scream, and made a threat that he would shoot me to death if I screamed and kill me by pressing my neck if I raised alarm. It is true that I never saw the boy earlier and did not know him. He left the house at about 4 PM after committing rape on me. Thereafter, I went to my parents in a run and narrated the incident to them. which is important, right? Therefore, my parents, elder brother and I came back to our house. Thereafter, my parents.
What is it that you want to point out?
Yes, my lord.
Yes.
Evidence, my lord, and the deposition of PW1, my lord. Page 19.
Hmm.
Contradiction, my lord.
Hmm.
My lord, page 19, my lord. Of 15. On oath, my lord. I have filed this case. I know the accused person about 3 years ago at about 1 p.m. That is, my lord, in FIR mentioned 3:30 p.m. my lord.
Oh,
Yes, my lord.
Minor 1 p.m., 2 p.m.,
Yes,
3
my lord.
p.m. What
Yes, my
difference does it?
When I was alone at my home, the accused person trespassed into my house and committed rape on me on gunpoint and fled away. I raised hue and cry, but nobody came. Then at about 2 p.m., my mother and brother returned back home from the paddy land. That is, my lord, in 164 stated that she went here, my lord, and here, my lord, say, my lord.
The issue is whether the incident happened or not. There is no contradiction with regard to that.
Yes, my lord.
It is, there is no contradiction that the offense
Yes, my lord.
did not take place. Or the place of occurrence is different. Nothing like that.
Yes, my lord. Can I read, my lord?
Hmm.
Then at about 2 p.m., my mother and brother returned back home from the paddy land, and I told about the occurrence to my mother. Then about 6 p.m., I, along with my mother and father, went to the police station. And I filed this case, my lord. Here, my lord, say on the same day they have filed FIR, my lord. In
How does these contradictions
this, my lord, on key 0.
dismantle, I mean, affect the what do you want to point out by these? These are minor contradictions.
The case to my lord.
Then
My lord, yeah, they have given in fact on paying the FIR file and 150% after 3 days FIR file, my lord. That was my lord. And the medical evidence also page 28, my lord.
hmm,
No body injury was, my lord. Only, my lord, attempt for sexual intercourse was prepared.
where is that?
Yes, page 28.
Hmm, yes.
Yes, my lord. On examination, I found the following, my lord. PW 10 medical officer, my
No
lord.
external injury.
Yes, my lord.
Hmm.
Victim was well oriented and healthy. No external injury was found on her body. Externally, no mark of injury was seen on her body. Hymen absent. As per the X-ray report of all the joints was fused and the age of the victim girl was above 18 years. Pregnancy test was negative. Spermatozoa was not detected on.
When was it caused? When was the medical test?
Yes, my lord. After, my lord.
When was the FIR lodged?
Around 0505 to
05. So it was examined on the next day.
Yes, next day.
Hmm. Prima facie, we don't find this a case where we can suspend the sentence. We can expedite the hearing of the appeal.
At this case, when 389 petition, board has to look the prima facie case, they court cannot re-appreciate the evidence at this. And my lord, recently one judgment Supreme Court has clearly said that, my lord, 389 petition can be allowed. 389 petition can be allowed only when there is a chance after going to the.
So the evidence.
That's why there is a chance of acquittal of the accused. Only that case, my lord.
We will take it up on some other day again. You apprise us. You take us through the evidence. The request of Mr. M. Purita, Learned Counsel for the petitioner. Matter be listed after a week, enabling him to apprise the court, address the court in respect of the evidences. Mr. R. Kaushik appears for the state list accordingly. Yes.
Item 51.
In item number 47, the box is pleased to keep the date 6.
Any possible on second matter because some personal difficulty.
Second is not possible. You take a Tuesday or a Thursday because it will require some hearing. We'll fix it on 13th if you want.
Six.
Yes, education.
Was on next, in on the alternative committee. I gone through Rule 50. Rule 50 only comes in when there is a departmental proceeding initiative. Here is a case where as part of pleadings also and as per contention also. there
Rule
was no
15 means alternative remedy.
Alternative remedy of appeal will come in only when Rule 9 is followed. There is a repeated case where disciplinary proceedings was not followed.
What basis you say that?
Lordship, there is an authority to it also. That's why I have already given the para 90.
Coordinate bench,
Yes, coordinate.
para 19.
Para 19, 2022, 6, DLT 445. Para 17, 18, it discusses about alternative remedy and its exceptions. Para 19. In the case in and admittedly, the principles of natural justice as contemplated under Rule 9 of Rules of 1964 and under Article 311 of Constitution of India were not followed. In as much as the penalty was imposed based on a report of an inquiry committee who had no sanction and authority under Assam Services Disciplinary Appeal Rules 1964 to recommend penalty. The same being not a departmental inquiry committee as contemplated under the said rules. Therefore, in the given facts and circumstances of the case, in view of the settled proposition of law, the arguments of Mr. Chutia, learned counsel is rejected.
No, this is the rejection of the learned counsel is in respect of remanding the matter to alternative remedy.
Yes.
But you said that this is also an authority to say that Rule 15 is applicable only if you follow the proceedings. Procedural prescribed under the 64 rules.
There are 70. The same plea was taken. The the case is identical. As per facts also, para 17. Now let us deal with the argument of Mr. Sutia learned counsel regarding alternative remedy. It is well settled. That's the
No. This is on a slightly different proposition. This is a case that there is an alternative remedy. Please relegate. You are urging a case that there is an alternative remedy besides the fact that it is not a bar for a writ court to exercise jurisdiction under 26. Fact remains that the rules of 69 were not followed. Therefore, there is no scope to say that there is an alternative remedy.
yes,
That is your argument.
That is my
But that argument, that proposition does not fall from this particular judgment. If you read carefully.
at Rule 16.
This is the proposition to say that there is an alternative remedy, ordinarily refer it. The court said that yes, ordinarily we refer it, but because no natural justice, etc., have been violated, we refuse to relegate the parties. Your case is that there is no alternative remedy because the rules in the first case were never followed.
Yes, Lordship, that is my.
Then that is not the proposition for this judgment.
Here also it was asked that there is
Yes,
yes, Lordship is correct.
there is a finer distinction between these two arguments. You come back with any authorities if you have. To get it back.
And moreover, Lordship, there is absolutely no departmental inquiry and it is absolutely without jurisdiction. In fact, Lordship, she based.
Would you like to come back with your argument or you are closing your argument?
No, I'll find it that.
Then you come back on some other day. Yes. Right, Mr. So-and-so. You, when can you come back? 6th
Yes,
or 8th? 8th. Come on 8th.
yes, Lordship.
Come on 8th.
Yes. And page 30, show cause also, show cause, there is no imposition of termination. Only show cause is given to for a different punishment. Therefore, there is no show cause effect in this case for this punishment.
1 minute. Okay.